May I pray for Lordship's leave to mention this matter? Now, this was heard by your Lordship and it was fixed on 12th at 2 p.m. Now, the difficulty is this 12th is a holiday. So, if your Lordship kindly have a look.
Very good. It will be placed on some other day.
Well, they are with the
Appellated 12th.
12th at 2 p.m. Lordship has already fixed these matters. Now, on the very next day, if you'll
do one thing,
yes, ma'am.
give a notice to the other side and come back and tell us on next Thursday.
Next Thursday.
Because 12th will be a holiday, so the matter cannot be taken up.
13th, if Lordship kindly, I can give notice 13th.
You mention on Thursday with notice. We will fix another date, fixing a particular
Thursday, next Thursday. Today's Thursday.
Today's Thursday, next Saturday, because Monday will be a holiday. No?
Monday will be a holiday.
Yes, yes. আপনি এখন বলবেন না, অ্যাডভোকেটদের সাহেবদের শেষ হলে তারপর বলবেন, পেছনে চলে যান।
In application of inclusion, my lord, I have served the notice. Inclusion for I served the notice other side. Application, my lord.
Old application.
My lord, application of appropriate order matter, my lord. File on 4th December, my lord. Senior citizen matter. I served the notice.
I mentioned at the beginning of December, your lordship.
Assigned to our bench.
Your lordship decided by your lordship. Bench decided by your lordship.
It has. Did it appear earlier?
Yes. Before the pujas, then there was a direction to come after the pujas. Then it did not come. Then I mentioned in at the beginning of
ওটা নিয়ে রাখো, ওটা একটু মনে করিয়ে দিও তাহলে।
December, then your lordship was pleased to direct me to come.
Sir, I was not there. I was in the circuit. We have come back. Let us see how we can arrange.
For that reason.
এটা মনে করিয়ে দিও।
My lord,
yes.
May I pray your lordships to mention a matter for inclusion in the list, my lord. Application under Group 8, my lord. It is
which year?
Old matter of 2012. It is only for extension of time to consider the representation.
Extension
of time to consider a representation.
Maybe you have.
It is pending for law.
Have you served notice?
Copy is served. Notice was earlier served.
Notice that you will mention today.
Give
a notice that you will mention next mentioning date and come back.
Second SLST. New application.
New application.
New application group 2.
Yes.
Lordship, I'm mentioning upon notice, your lordship. This is an assigned matter, MAT number 1509 of 2015, your lordship. This is a 2015 matter, your lordship. This has been appearing in the list but not been taken up, your lordship. Your lordship, I am for the successful auction purchaser in this, your lordship. Bona fide auction purchaser.
It is in the list?
Yes, your lordship, but it's in the monthly list, your lordship. It's in the monthly list. Monthly list.
The list was called on once, first of all. This month also we combined list combined list দেখেছিলাম না? It is called on. Madam, please be here when the monthly list is called on. Matters are called on, whichever matter is mentioned, either we hear it out or we fix a date in a supplementary list. If you don't appear and remind us, we cannot assist.
Your lordship, my learned junior was here. She informed me that 59 was not called on, your lordship.
We are 15 কত অবধি? All right, wait for 2 weeks. If the combined list is called, ask your junior to remind us so that we can fix a particular date. If not,
your lordship, may I be permitted to mention one matter? This is a physical education matter for higher pay scale, your lordship. And every time the applicant is praying for adjournment, your lordship. It is Mosumi Roy matter, your lordship.
When was it filed? When it is a state appeal?
A state appeal, your lordship. Large
notice to the state.
I have served through WhatsApp.
Mentioned today.
Yes, your lordship.
Why through WhatsApp? You give a notice to your other side.
I tried yesterday. He left the court. That's why I have served through WhatsApp, your lordship.
When it has been made returnable?
This was the last time I have mentioned this matter, and your lordship, this matter was called on, and the appellant pays for adjournment. That
not your appeal, sir. It
no.
is state's appeal.
Yes, your lordship.
So they are not mentioning if they do not have the appeal heard out. You avail your appropriate remedies. What is the problem?
I am not getting my the higher.
For that you have to file a contempt, na? Have you?
I have filed, but the matter is pending before the division bench. That's why the single bench did not have.
Why we haven't not stayed the order?
No, your lordship.
So when it was last heard?
That date was after puja vacation, your lordship.
The notice to them that you will mention next Thursday and come back. Yes.
Grateful to your lordship.
I seek my lord's kind leave to mention the inclusion of an application, my lord. For some precedence, my lord, there is some urgency in the matter. My lord,
When application filed?
my lord, application filed in 2025, my lord, December, my lord.
Then what makes you to mention today? It was heard earlier.
My lord, it was not, it's new application, my lord.
Have you served notice of
My lord,
order? Are you in notice or not?
Sir,
Where? Show us the notice.
put a notice.
Every day we remind the advocates, kindly serve a notice and come.
Notice, sir.
What do you
Notice,
mean?
sir.
My lord, notice has been.
Yes.
May I have my lord's kind leave to mention upon notice MAT 2171 of 2025 filed in December 2025. This is pertaining to the supernumerary positions. This is an
What is the matter? Did it appear?
no, it hasn't appeared, my lord. It's a new appeal
Yes.
for
give this
inclusion.
Your lordship.
এগুলো যেগুলো নিউ এগুলো অ্যাকর্ডিংলি লিস্টে দিয়ে দিও রিকুইজিশন করিয়ে করে দিও।
Very pleased to recall 5th of January, I and Mr. Rahul Singh mentioned the matters regarding the contempts regarding Rajiv Brahmo matter. Your lordships were pleased to direct us to take the consent of the learned advocate general when he'll be available. My lord, Mr. Rahul Singh had already contacted and discussed the matter with the learned advocate general.
Yes, Dr. Patra.
In January, he has consented 15th.
হ্যাঁ
Your lordship wanted the time, at which time he will be available. My lord, 15th January at 2 p.m.
2
If your
p.m.,
lordship
yes.
can kindly fix the matter.
15
Can,
January.
because your lordships,
Wait, we have understood your this. 15 January কিছু আছে কি? Huh? No, 15th it cannot be done. We have a part heard that fixed at 3 p.m. 3 p.m. na 2 p.m. 2 p.m.
না ঢুকো। আপনাকে বলতে হবে তো ওকে।
এই রাহুল জয়েন করেনি
আমাকে বল জয়।
কারণ কিশোরদা বলেছিল সারাদিন ফ্রি আছি কিশোরদা বলেছিল সারাদিন ফ্রি আছি লেট ইট বি ইন দি ফার্স্ট হাফ সেটা রাহুলকে বলতে হবে।
শুনছে কথা বলছে না মানে
রাহুলকে বল।
পঙ্গু হয়ে যাবে।
ঠিক আছে 15th ওটা 2 p.m. ফার্স্ট ম্যাটার করে রাখ।
ভেরি গুড ঠিক আছে
Yes.
Well, may I permitted to mention some analogous matter, Monday.
Yes.
The may permitted to mention in our original site, the new court application.
Group 2.
Group 2, my lord, the original site, my lord. I have filed recently with my lord the notice of the other side, and my lord deputy service has been filed also, my lord, along with the application.
আপনার কোশ্চেন রিজিনাল সাইট পার্থর সাথে আছে না?
Supposed to appear today. It is a appeal arising out of an order dated 19th December.
Supposed to appear today means?
But it was given. The returnable was today.
So was that the order?
No, my lord. It was filed. This is a fresh appeal, my lord.
So returnable today, who told you?
But in the form A, my lord, the returnable date was given.
It will come in due course. After these appeals are filed, we cannot include it in the list because of non-availability of the file.
Well,
it is a new application.
It's a new application.
To give a copy. Requisition pathao dekhiye nahi. Yes.
Oblige.
My lord, may I be permitted to mention, my lord, for inclusion in the list, my lord?
Application.
Application.
PGR.
My lord.
Are you mentioning upon notice?
Yes, my lord. Notice, my lord. I have.
When was it last heard?
No, never heard. It is the fresh. First time, my lord.
Filed recently?
No,
Then
my lord, filed earlier, my lord, but yeah, I could not mention it.
filed earlier means
Earlier
when?
means, my lord, 2024, or can, my lord,
Mention after 2 weeks, yes.
Lord, may I permitted to some analogous matter? My lord, Monday I mentioned, my lord has asked for the list when, my lord, the analogous matters list, my lord, on 27/11/2025 matter was heard. My lord, my lord, will remember, my lord, some petitioner in person came before your lordship and my lord called us, and thereafter, my lord, time.
Just wait for your turn.
My lord,
Remember that.
my lord, there is some urgency. My lord, yesterday, my lord,
Wait.
my lord, yesterday merit list is published. My lord, if the seats are filled up by the other candidate, my lord, single when specific order is there, my lord, contempt petition is pending due to, my lord, this
Appeal preferred by whom?
by the board, my lord.
So it's board's
My
appeal.
lord, then, my lord, allow my contempt applications, my lord. Otherwise, my lord,
You allow, we haven't stayed the order. Proceeding contempt, who has stopped you?
my lord, kindly, my lord, then allow.
Who has stopped you, madam? Yes, any other mentioning?
My lord, the application, new application, madam.
It's only critical means, my lord.
Yes.
Contempt is there, my lord.
The Ratul Bishwas.
Where is your notice to him? That
My lord, on Monday I give notice, my lord, due to, my lord, urgency, my lord, yesterday evening the list is published, my lord, and that is why, my lord, merit list of the 2000 session 2020 and 2022.
So why didn't you mention earlier?
My lord, earlier it was mentioned, my lord, my lord,
She's saying she has
my lord, when I mentioned Monday, that notice was served. My lord, today, my lord,
whether you have served.
but today's mentioning no notice was served due to, my lord, urgency. Yesterday evening the list was published. That's why, my lord, I
They could have mailed us. Even they mail us regarding the mentioning, but no mail I have checked today morning.
No, what is that? Any list is being published?
I don't know.
Yes, your lordship, I bring the notice.
I have no knowledge, lordship. What's in which matter?
No, on Monday notice was given.
Monday, if she is saying that that may be given, but today morning I have checked that no.
No, very good. Now, Monday it was given. Then what happened? Is it a fact that list is being published?
Yes, my lord, I bring the notice. This yesterday this notice is published, my lord.
Any interim order was passed?
No, my lord, no. Only request was made on earlier.
Where is your contempt fixed?
My lord, contempt, my lord, this is my contempt application number, my lord.
Then why didn't you mention for the contempt?
My lord, contempt was moved. It was served, but by the bench, my lord, it was requested since the appeal is pending. My lord, no order is, though, my lord, though not interim order is passed, but only, my lord.
It is so urgent, you will not go in contempt and insist for hearing.
My lord,
everybody is here before us.
My lord, kindly, my lord, see this order, my
Take
lord.
up your papers and mention later. Go to that side. Check up the papers and mention. Yes.
The only thing, my lord, the contempt application is, my lord, contempt application in this matter is pending, my lord. It will come.
So what did you do for 1 year?
My lord, application was filed in the year 2025. Thereafter, my lord, I could not mention. I am grateful.
My lord, may I be permitted to mention this matter for inclusion, my lord?
New or old?
New matter, my lord.
Yes. হ্যাঁ বলুন কি বলছেন?
The petitioner in person is saying urgent listing and hearing with one.
After advocate K.
I am appearing in person, Your Lordship.
Achha.
Notice served to the Kishore Karmakar through email dated 6 January 2026 to 12:53 p.m.
What is it? এটা কি লিস্টে আছে কম্বাইন্ড লিস্টে?
No, no.
এসেছিল আগে?
The Chief Justice Office actually informed me and for appearing before Your Lordship because ether section already sent the file.
একটু দেখে নাও তাহলে, ইন পার্সন মেনশন করছে, হলে দিয়ে দাও তাহলে।
I place the, my lord, contempt order, my lord. It was specifically, my lord, laid this.
Don't have to read to us the order.
My lord, it was not taken up due, my lord, due to the pendency of the appeal.
First of all, you send the clients. You do not have.
My lord, I never, my lord.
Send the clients. Clients came and mentioned.
My lord, it was mentioned, my lord, it was hard on 27/11.
Firdos Samim came and said, I will retire from the matter. This is the entire process by which you get the matter listed. When other matters are standing in the queue.
But it was
this conduct is not acceptable.
My lord, it was listed on 27/11. My lord, it was hard, my lord. Thereafter, it was adjourned, my lord. After that, my lord, without
27th, why it was adjourned?
My lord, due to, my lord, the respondent.
Yes, 27th, it was adjourned at your
My lord, I bring the list, my lord. 27th, ইয়ে হয়েছিল adjourn হয়েছিল next day.
এইটা কি ওই ম্যাটার দেখাচ্ছিলে আপডেটেড ম্যাটার দেখি দাও দেখি
Item number 30 onwards. Onwards, my lord. 30 to 44, my lord. My lord, 31 onwards is my matter, my lord.
Then why it was not taken up? It was taken up, what adjournment was sought for?
My lord, not this week was, my lord, on.
Why? At whose instance? You must have not been there.
No, my lord. My lord, I along with, my lord, another brief, my lord, Mr.
Procedural. 27th, yes or no?
Yes, your lordship. Huh? Yes, your lordship. But it was not, my lord.
But then why it was adjourned? Why didn't you tell us?
It was adjourned because
27th, why it was adjourned? It was on your behalf.
No,
At that time, you had no urgency. Matter was allowed to be adjourned. Hearing.
No, it is application stage.
Application stage. এটা মঙ্গলবার দিনকে দিয়ে রেখো লিস্ট। Please be present at the time.
My lord,
Just call the list.
Gossip, may I get a list from what?
Do whatever you want. If they do not give you, you proceed. We are not here to request her. Please send, please send.
Grateful, your lordship.
So I beg to appear on behalf of the petitioner. So this is the family pension matter. On the basis of the DI, but they have made that the school authority calculation has been made to us. We have deposited the amount as sought for, but TR7 challan with me. Only one thing we could not, because the legal year certificate they sought for. Now legal year certificate is to be issued by the district magistrate. It will take much time. On 2nd December, we have deposited the amount.
Yes.
The copy আছে?
Yes, have you brought the judgment? Which was allowed the CPF, GPF?
Yes, that is annexed here.
But we are already processing his case.
Uh-huh.
We are already processing his case. But he has already deposited the amount as we have supplied the calculation sheet. He has already deposited the amount. Only one document is required, legal year certificate from the district magistrate, which is required to finalize the case, my lord. But he is yet to release the amount. But he is yet to receive the legal year certificate from the district magistrate.
So we will dispose of the appeal, set aside the order, dispose of the appeal, and we will record that he has paid the. This is the CPF contribution.
Yes.
Huh?
Yes.
Together with interest. CPF together with interest, the entire amount has been deposited.
Acha, show us that order which has allowed this division bench order.
Yes.
Not Obijit Vaidya, subsequent order.
Yes. Shefali Jana, page 12 of the application.
Page 12?
Yes.
Page 12 of the stay application.
Yes. The application for appropriate order. One application.
Page 12 to name.
That
Appropriate order, yes.
page 12.
It starts from 10.
10 is.
Durgarani Kamar.
No, that is the.
No.
Ugarani Kamar.
Oh, page 12. Page 12.
Yes.
Achha.
This is under chapter. Page 12 is the.
The present appeal has been preferred, challenging an order
In this matter, my lord, I am appearing for the appellant petitioner, my lord. Yeah, my lord. চিঠি দিয়েছে আমি কি বলবো আমার তো কিছু বলার নেই বলুন তাহলে আপনি কি করবেন
Yes.
This is the case of recruitment process 2009 for appointment of primary school teachers. An advertisement was made, petitioner applied for the same. Then the petitioner was called for written test, petitioner appeared for written test, he passed the written test. Then petitioner was called for interview. He appeared for interview. He answered all questions put to him, but unfortunately he was given only 1 mark in the interview. Then petitioner sent RTI application, my lord, your lordship kindly come up, page 26, my lord, wherein reply was given.
Page
26, my lord. Page 26, my lord.
Yes.
Wherein it has been mentioned, my lord, the petitioner got 26.28 marks, my lord. Who have got the 26.28 marks, my lord, their names were included in the waiting list and they are given the appointment, my lord. Your lordship
Those
kindly
who
come
got?
up. Yes, 28, my lord.
Yes.
Your name, serial number? 20 and 21, my lord. Who got, my lord, 26.28, 26.28, my lord. 20 and 21, my lord. They are given appointment, my lord.
Yes.
Only, my lord.
When was the appointment given? 2007.
No, my lord. Last, my lord, approval was made, my lord, October 2024.
Then
Approval
the
was
court
made.
has said similar writ petitions were filed.
Yes, my lord.
And is
That
this
order-
a fact that order restricted up to 31st March 24?
No. That was the district of Howrah, my lord. This is the order of the. This is the order of district North 24 Parganas.
This 2009 selection process was challenged in
Yes, ma'am.
several writ petitions.
It has been mentioned, my lord, in the Honorable Single Das, my lord. Your lordship kindly come up, paragraph 7, my lord. Paragraph 7, my lord, of the Single Das order, my lord. Wherein, my lord, it has been specifically mentioned, my lord, the one report was submitted by the commissioner. Wherein it has been mentioned, my lord, 800 posts.
Read paragraph 7. Which paragraph you are placing?
Paragraph 7, my lord, of the Honorable.
Yes, read it.
The recruitment process is of the year 2009, which was completed by issuing appointments in the year 2021. After taking into consideration the vacancies already existing, that the new post of 2,605 created, it transferred to this court from the report that the submissions of the Commissioner of School Education, the DPSC North 24 Parganas, and the petitioner that there are about 800 posts still vacant, my lord.
Yes.
If the respondents, my lord, if the respondents given the reply.
Read the order, na. You have read, we have to read, na. Paragraph 7, then read.
Then Milord, para 13 Milord.
Paragraph 9, kindly read.
Yes, yes, Milord. In a decision of a coordinate bench in respect of Howrah, DPSC by the order dated 9th April 2024, a consensus was achieved by the consent of all parties. That is the writ petitioner that DPSC concerned the Commissioner of School Education to accommodate the petitioner in all writ applications filed up to 31st March 2024 to be appointed against available vacancies.
Very good.
This was the district of Howrah, Milord.
You are in which district?
Not 24 Parganas, Milord. That was 13 Milord.
Paragraph?
13 Milord.
Paragraph 13, yes. So,
in the above circumstances, following the order dated 9th April 2024, passed in WP number such and such, for the reasons stated herein in respect of DPSC Howrah, this court by consent of all parties is inclined to direct the all candidates who are called for interview in the appropriate recruitment process of the year 2009 and have filed writ petition until 24th April 2024 shall be entitled to appointments against.
But this date differs with paragraph 9. That was 31st March 2024.
That was in the district of Howrah, Milord.
But in respect of
that was mentioned in the order.
24th April 2024.
Yes, Milord. That was
North
the.
Chobbish Pargana.
Yes, Milord.
So you are a candidate of North Chobbish
Yes,
Pargana. So when you filed the writ petition?
But your lordship, that was, Milord. First RTI application was made.
It is North Chobbish Pargana.
Yes, Milord.
It is Howrah ব্যাপার।
No, Howrah coordinate.
That was mentioned, Milord, in the Honorable Single Judge, Milord, Howrah district, Milord.
এখানেও এই যে অর্ডারে নর্থ চব্বিশ পরগনা
Yes, Milord.
is a candidate of not
24 Parganas.
Not 24 Parganas.
So in your case, 24th April will be the cutoff.
Cutoff.
Yes, Milord. I am submitting before your lordship, Milord. First RTI application was made, Milord, on 26 July 2023. 26 July 2023. Your lordship kindly come up page 23 AR. A. As RTI application was made. That was not given any reply.
There was a provision for appeal.
Page 23 A.
Section 19.
19.1 and thereafter second appeal 92.
Second
As
appeal
RTI
is
application.
19.3.
92.
19.2. Second appeal is there.
Second appeal. Under RTI.
If
As application was made, Milord, on 26 July 2023.
So your contention is, as you are not furnished appropriate instruction, you could not file the writ petition.
Within the 23, Milord.
So, but that is your fault, sir.
No, Milord.
Because 26
sorry to
July
say, Milord.
23, 26 July 23, you submitted the application for RTI.
Yes, Milord.
So the cutoff date was 24th April 2024.
24, Milord.
But you immediately did not take any steps that I am not getting the information. You give it immediately. You could have preferred appeal within the time specified. Now how we can extend the date when it has already been fixed?
I am submitting, Milord, if the respondents given the reply of RTI application within the time being, Milord, then petitioner could have to come, Milord.
But in that case, how can we?
I am also submitting, since, Milord, hundreds and hundreds outsiders, unsuccessful candidates, Milord, are given appointment. Petitioner is genuine and successful candidates, Milord.
Moreover, that order
and Milord, same who has got the same number like that the petitioners, Milord, he has already been given appointment. This is very. This is discrimination also, Milord. Page 28, Milord.
No appeal has been prepared challenging this order. And we are also cannot set aside this order.
Maybe consider to
sit in appeal over this
but
order.
the same number candidates, Milord, have been considered, Milord. Page 28, Milord. Here number 20 and 21, Milord.
Strictly speaking, we cutoff is not applicable because that was an order on consent.
And Milord, vacancies are still there.
Consented order. Consented
Consent of all parties.
That was
আমার right কেন ছিল?
Thereafter, my lord, that was mentioned in the order, my lord. That was court's order, my lord.
দিলেও কে রিলিফ দিতে পারছো না। Strictly speaking, a consented order cannot be treated as a cut-off date fixed, even there had been discrimination.
This content is not binding upon you.
Not binding.
Right. You know,
Since, my lord, there is no cut-off date
Mr.
filing.
Dole, you are for the commission.
I'm for the state, my lord. The commission should be present.
Who is the council?
Not,
This is
Bhaskar
with Pinaki Bhattacharya.
Bhaskar Ghosh and Pinaki Bharsas.
now, Mr. Dole, only one thing. All right, cut off, he did not come, whatever may be the excuse. But that was an order on consent. A consent order between the parties cannot bind a third party who has an independent right to be considered. Subject to correction. Subject to correction.
My lord, that, my lord, the commission should be present, my lord. He should, my lord, address on
you
this
give
point.
notice to Mr. Oisho.
Pinaki Ranjan Bhattacharya, where is who has been engaged? Do you know who has been engaged?
Actually, for DPSC, he has appeared.
He has appeared earlier.
Yes, my lord, in the court, my lord, earlier court.
Earlier single means order, my lord.
My lord, kindly see
It has been mentioned the name.
DPSC, not 24 Parliament.
Hardly learned advocates. Stop.
Copy service করে দিয়েছে আবার দিয়ে দিয়ে দুবার
Give a copy. Give a
দুবার
copy.
দিয়েছে ওই তো রয়েছে ওখানে
আরেকটা copy দিয়ে দিন না।
দিন একটা
সার্ভিস দিয়ে কি হবে?
এর আগেও তো দিয়েছেন ওই সুবির মামা আচ্ছা ঠিক আছে দিয়ে দেবেন আমি অসুবিধা নেই ঠিক
No, this is one day accommodation will not help. Here it is the issue that writ petition has been dismissed since in earlier matters a cut-off date was fixed that whoever comes files writ petition within that period, they will be considered. But he came later. That is why his petition was dismissed. What we want to know from you is that cut-off date of 24th April would be binding upon him or not, because that 24th April order was a consent order. Followed the point. আচ্ছা, এরকম লেখো, Mr. Sarkar, learned advocate appearing
Section 6 of RTI, he could not come in court within that time. However, the date was fixed by consent of the parties. Consent means one time of agreement in between the parties to that proceeding. That date cannot be binding upon him.
मतलब same identical matter, my lord, heard by the Honorable Justice Mantha. Thereafter, my lord, appeal was preferred by the Honorable Justice Moshak, dismissed. Thereafter, SLP filed, SLP dismissed. I shall come.
Okay,
all
bring that.
documents.
Yes, bring that.
No, but ascertain whether what he is saying, marks obtained by whether person securing lesser marks have been appointed.
Yes, ma'am. I am grateful.
You also ascertain that point and come back. Copy রাখবে. Fourth will be a bit too far. We are keeping on 27th.
Yes.
2 weeks we are giving him. And you bring all those orders. You dispose of them. Yes, 27th.
I am grateful.
Yes, next.
I'm for the petitioner. I'm led by Mr. Dakshulika Raj Putro. He is on his legs in courtroom number 2, my lord. Paying for not today.
The earlier date also adjourned. देखिए order টা দাও. 1 year prayer it was us. What is the matter? You are advocate on record.
Yes, ma'am.
তাহলে tell us now what is the matter?
Matter is regarding 300 marks requirement in second SLST 2025.
Yes.
Yes.
Who is for the School Service Commission?
Dr. Patri is for the commission, my lord.
Oh, अच्छा. কি বলেছে? Admittedly, you don't have that qualification. What can be done?
My lord, the requirement is 300 marks, but
Yes.
he has studied that subject for 240 marks.
Right.
240 full marks. So it is not permitted under that syllabus structure to study the subject for 300 full marks.
There, for that you have to suffer.
My lord,
For that you cannot now come and say that you treat me as equivalent to the persons as detailed in note 1. How can you say that, mister? Your university provided 240 marks for that qualification. Now
For that
they are
particular subject.
in their notification, they are saying the combination subject must be of 300 marks. Your argument is that the university in which I studied, there was no provision for 300
Well,
marks
not
paper.
only the university, the syllabus structure, the CBC
Very good, whatever it may be.
Yes, Your Lordship.
But 300 marks, it was, you have admittedly not obtained that. Now, how can you be permitted to participate in the selection? Now, what is the stage? Selection process has started.
Yes, Your Lordship.
Yes, what is the stage of the selection process? 30th of May 2025. Now, selection process has concluded.
No, my lord, the verification stage is going on.
Verification stage. Then how can we help you? Tell us.
Kindly short pass over, my lord. My senior is engaged in courtroom number 2.
Your Lordship, kindly keep it on Monday.
You have not challenged the notification or any rule by prescribing 300 marks.
I have prayed for modification.
Formula I beg to appear the I beg to appear on with the West Bengal State University. It is that matter your Lordship kindly recalls.
This is a mark sheet.
Mark sheet.
That report you have brought?
Yes, yes.
CBI report?
Yes, yes. On the last occasion, I have filed it. And I also have a copy
Yes,
of.
yes. I have got it.
Then what do you say, Mr. Mitra?
Milord,
Take instruction.
Milord, yes, yes. Milord, I have taken instruction. Milord, we have categorically, repeatedly told them, Milord, that the post-review mark sheet, which is alleged to be fake,
Right.
that is not matching with our database records. So we cannot, Milord, give any.
But then how can you avoid this report?
Well, that is the Milord.
In that case, seeing the report, you allow.
In that case, Milord, if your Lordship kindly goes through the Milord CID report, your Lordship would find that Milord, we didn't have any documents. Milord, CID asked for certain documents it didn't have.
Same state of affairs. In that case,
maybe
you
or
allow.
may not be. Maybe may not be. Milord, in respect
So
of.
you tell us that why may not be. When in case of a person similar cause of action, similar grievance was ventilated, police was directed to conduct. Police came with a report, and on that basis, seeing that report, you considered.
Lordship.
You said that yes, I will give.
But thereafter, Milord, two judgments, Milord, I have relied upon one.
After
by
concession, what
coordinate bench
judgment will
and another Milord division bench.
Mr. Moitro, kindly ascertain.
Yes.
Similarly situated person moved a petition.
Yes.
In that case also the records were missing.
Yes.
Did court said that police should conduct an investigation and come back to me. When the police came back with that report, you considered that all right, this person I am allowing.
No, Milord, what we said, we did, Milord. Since Milord, CID, Milord, gave a report, Milord, that
ওই রিপোর্টটা ফার্দার আমরা ইন্টারপ্রেট করবো কি not take instructions
Yes,
and
yes,
come
yes.
back.
Very good, very good. Yes, yes.
Otherwise, we have to decide on merit.
Yes, yes, yes. I would come back.
He has completed his argument.
Yes, yes, yes. Yes.
You have also
Well, he
told
also
us
completed his argument.
two Supreme Court judges.
Only Miller, kindly see Miller, the order passed by Justice Chando. It says Miller, today when the matter is taken up for hearing, the university submits that after perusal of the said report, the university has decided to issue necessary certificate in favor of the petitioner within the period of 2 weeks from date.
Well, kindly also takes notes of the Millard, one judgment of the coordinate bench in one
Facts are
similar
different.
facts. No, facts are not. Similar
Absolutely
facts
different.
and circumstances, and Millard, the order of the Honorable Division Bench.
Facts are absolutely different, Miller.
Same Millard fake mark sheet.
No
All
investigation.
right, Mr. Moitro, we have completed the hearing. So if you show this order to your authorities
Yes.
and you put this question, if they say that no, that cannot
But
be
I'll
a
come
ground.
back. I'll come back.
If that is so, then we will deliver the
Yes,
judgment.
yes, well, I'll come back.
As you are our officer, we
Yes,
are
yes.
wanting to
Definitely,
know.
certainly. I have read your lordship's mind. I will come back.
And suppose the university can certainly deny. University can say that the facts and circumstances in that matter are not similar to this. It does not tally
The
with our
difficulty is this: if we
floodgate.
yes,
We know.
yes,
You have a talk, but you have a talk with the university because that was a concession on your
what
part.
they did, my lord, in that case also, my lord, passed in the year 2012 or 14, waited till 2017-19. When the employer asks for the, my lord, original mark sheet, they now
Same thing,
same thing, same mode of apprendi.
Mr. Moitro, the thing is,
মিথ্যা তো বলে দিয়েছে, আমি বারবার ইচ্ছা করে বলছি।
Page 3, Miller, today.
ঠিক আছে। না রে, আমার অপোজিশন রিপ্লাইটা কথা আমার অপোজিশন রিপ্লাইটা কথা
Mr. Moitro, you tell us that we pass our order. If you do not, we can, you are our officer. You can ask for an instruction. You cannot tell them that you need to do this. So you tell us when will you come? We will keep it at for orders and pass the order.
After 26 January.
26 January.
After 26 January.
Why? Prior to that, সরাসরি তার আগে করবে 23 তারিখের আগে 22 তারিখে
27th or 20th, subject to your lordship kind convenience. 27th or 28th.
The 28th we are keeping. By that,
Had the landed advocate appealing for the respective party release the matter for further
Who is for the state now? You are for the state.
Nine, seven I'm for the state, but 5, 6, 7 is the decrease 7.
7. Same matter, Mr. Sharma. 7.
My lord, I am not aware. I am only in 5.
Similar, my lord. 5 to 7 similar.
আমি তো নেই মানে।
In 5, Mr. Sannal, Bishobrata Bosu only appeared. So he is not in the panel. I don't know if anybody is
Thereafter, in the appeal, Supriyo Chattopadhyay appeared
for the state.
for the state.
In the 7.
Uh-huh.
Priya Chattopadhyay and me is in 7. MAT 1404 of 20.
No, but you can also appear in 1103. Similar matter, no?
So Lordship direct.
Where is Mr. Chattopadhyay? Mr. Sannal, we are coming back after 5 minutes. In the meantime, you call Mr. Supriyo Chattopadhyay.
Can we also come back with a cup of coffee then?
We are not going for a cup of. No, you tell us when you are.
No, I'm ready. Right?
Please see if Mr. Chattopadhyay is there, then we can.
He's saying that Mr.
Is hospitalized. I'm just in the morning. His clerk said me, Mr. Chattopadhyay, Supriyo Chattopadhyay.
আপনি শুনুন না। আপনি তো আছেন।
No, no. Do you know who has been engaged for the state? This was Bishobrata Bosu only.
Oh, no panel.
He is not in the panel.
My guess is that because in all respect of all matters where Mr. Basu Mollik appeared, Mr. Chattopadhyay is appearing. That's
If Mr. Chattopadhyay comes, we will engage him and he will appear.
But let us continue because it will take time, your lordships. It's not that it will be because let him take notes and because he's on advocate record. Are engagement to Judge Sahib kore debe.
When is Mr. Chattopadhyay coming back?
Lordship, actually, I heard that his mother is not well. So let it be kept in the next week then, Lordship. So
আচ্ছা next Tuesday রেখে দাও Tuesday
SIR এর hearing আছে তার কালকে।
Well, he has been called for SIR hearing on Tuesday. I don't know. Malade Bowbajar
5 to 7.
all we will take it up.
next.
8 Millard, I appear for the appellant Millard. I am led by Mr. Vishnu Bhattacharya.
Yes.
I am for the school.
I am on the statement.
I am for the writ petition.
I am assailing the order dated
Yes,
11th.
just one moment. Order is at page
Page Millard 113. Impugned.
130.
113.
Review.
113, Malad.
Can.
113. 11 June 25.
Yes.
11 June 25.
Yes, Malad. একশো তেরো কথা দেখবো
Yes.
Millard, the moot question in this matter is whether
You are the respondent number 9 in the writ petition.
9 in the
You are
writ
the
application.
school.
No, I
I'm
am
the headmaster.
headmaster.
You are
Allegation against me for defalcation of fund of school at the behest of some guardian.
no, Nikhil Mondal
Yes,
and
Malad.
others.
That I am appearing for
Guardians.
guardians.
Oh,
Guardians of the schools, Malad. Our words are starting in the schools, Malad. So, Malad, there are certain defalcation of funds, Malad, and irregularities committed by the headmaster in the school premises. We have made several complaints before the authorities. Malad,
no steps were
no
being
steps were
taken.
taken. We approached the Honorable
Court said that already
inquiry. Court said, Malad, the district inspector of school to make an preliminary inquiry. And in the inquiry, Malad, it is found that several allegations and which has been leveled against us by against the headmaster are proved.
very good. Then what happened?
Then, my lord, then, my lord, district inspector of school forwarded the inquiry report to the West Bengal Board of Secondary Education for taking steps whether the disciplinary proceedings is required to be initiated or not. In the meantime, my lord, the writ petitioner, my lord, respondent number 9, appellant in the present appeal, my lord, retired. So, my lord, during pendency of the writ petition, and then, my lord, the West Bengal Board of Secondary Education, my lord, says that, my lord, after retirement, my lord, we have to take, my lord, and approval from the Education Department for initiation of proceedings. My lord, ultimately, my lord, on, my lord, 9 June 2025, Secretary Education Department, my lord, grant approval for initiation of proceedings against the headmaster. This is the facts, my lord.
Yes, Mr. Bhattacharya.
Now, please come to page 94 for a moment. This is the trigger. The first, before anything else,
no, Mr. Bhattacharya, what has been decided in the writ petition?
Milord,
There
today,
is no decision.
today, Milord, the writ petition is at the instance of
Guardians. It was not maintainable.
Milord, apart from the issue of locus, Milord, whether in a writ petition carried by the guardians, Milord, such a direction by resorting to various documents, internal documents.
So you challenge that
No,
decision?
kindly, I have
You have challenged the
participated in the proceeding, seeking to raise my defense. Now, today kindly visualize the position. If I may, kindly gives me 2 minutes. First sees, I request your lordship to kindly take the supplementary affidavit once before I show your lordship anything else. Please see page 27. Please see page 27. It begins the rules. And we are concerned with rule 5 at page, this will be page 31.
page 31.
Yes, the board may, I'm looking at rule 5. The board may authorize, this is the 2018 rules, may authorize any officer not below the rank of SI of schools to conduct preliminary investigation against any teacher or non-teaching staff upon receipt of a complaint pertaining to the misconduct of the teacher and non-teaching staff from the committee or the administrator or head of an institution. Pausing here. Milord keeps this side by side and please falls back to page 94.
Of the stay
Of the writ petition, yeah, of the stay application, yes.
'94.
Now, your lordship has read 5.1.
Yes.
Legible copies. I do not know whether it is how far it is legible. The my lord kept to Devan. Just give me 1 second. Yes. For both my lords. Sorry, my lord. Where an inquiry report, as my lord very kindly got it. This is the first. 5.1 stage is this. Whereas an inquiry report has been submitted by the DI of schools SE Malda. Allegations, my lord, recorded. Allegation of opening such and such, allegation of failing such and such, allegation of overwriting, allegation of failing to produce vouchers, etc. Ultimately, my lord, your explanation along with copies of all supporting documents should reach this office within 7 days. So, my lord, first is this inquiry report. Nowhere this inquiry report is disclosed to me.
Not disclosed.
Not disclosed. Now, my lord, assuming today immediately, my lord, at least I do not find it has been disclosed. A statement would be taken, a point would be taken that I have given a response to this. Where is it recorded? My lord, please come to now, my lord, the second show cause. Page 101. This I responded to. Then, my lord, page 101. They called me for a hearing on 28th of January 2025.
After this show cause?
Yes.
Yes.
And then, my lord, they
initiate a proceeding.
No. This is the order, my lord, at page 104. After hearing, the deputy secretary, being the disciplinary authority, communicates to my advocate. To my advocate, enclosing a copy of the report. Now, please see. Kindly take the trouble to straightway come to 106.
Yes.
This case relates to the complaint. My lord, putting a question to myself. At least, my lord, previously, my lord, your lordship knows better than any one of us. We have learnt it, my lord, 28.8. Natural justice was read into it. Old rules. Management rules, 1969. Natural justice was read into 28.8. And, my lord, all documents.
Challenge this.
My lord, please see, nothing is disclosed.
Take that ground.
My lord, I can. I am before the division bench. Today,
how can on their petition you can claim a relief?
My lord, it is now my appeal. My lord, kindly sees what are the findings. Kindly sees for a moment. I'll stop.
The court has said we find that a proceeding has been initiated.
Lord, this.
We
Lord,
will say this order will not prejudice you in any manner for challenging the show cause.
Two things today. Whatever little that we know from your lordships, may not by series of orders and may not by judicial pronouncements, at least I am entitled to a provisional pension. If there is a proceeding, assuming is initiated.
Certainly.
May not, I am entitled to my own contribution to my provident fund. At least, may not, these amounts, I have been writing to them, pestering the authorities, may not, to release these amounts. May not, I have not seen a
funding. When did you retire?
May not, I retired in 2024.
Date.
I'll just give you a lordship the date.
30th June 2024.
30th June 2024.
Yes.
Now today, apropos some hearing, Lord, kindly takes the trouble to please come to 107 once.
So your first ground is that no such inquiry report was given to you.
No documents given to me, no complaint given to me, nothing given to me.
In the hearing which you called,
I attended the hearing. Maybe he was.
Point.
Well, obvious reasons,
He
no.
was absent in the hearing, Your Lordship. He didn't attend the hearing. It is written.
I did
That
not.
charge sheet has been issued.
No.
Yes. If in the charge sheet they relied upon the preliminary inquiry report, then only we will be entitled to
Respect.
Yes.
With respect.
You wait, you see whether in the list of documents or anywhere, preliminary inquiry report has been relied upon or sought to be relied upon by the
only I am grateful to my Lord Justice Chatterjee, my Lord.
set a preliminary inquiry to ascertain.
My lord, inquiry report was also, my lord, served upon the learned advocate, my lord.
To ascertain. Ultimately, they come to a
Rule 5, there is a provision in Rule 5.
In hearing,
they come to a conclusion that yes, sufficient material existed to proceed against this person or to initiate disciplinary proceedings.
তুমি বলো, তুমি তো দিয়েছিলে।
Now, my lord, please.
রিপোর্টে দেওয়া হয়েছিল।
কিন্তু রিলাই করতে বাধ্য ওরা। প্রমাণই করতে পারে।
হ্যাঁ, নাহলে যখন
আমাকে দিলে ইয়েকে কোর্টেরই দিয়েছিল।
চাইবে ওখানে স্টেটমেন্ট অফ ডিফেন্স চাইবে, প্রিমিয়ার ইনকোয়ারি চাইবে যে আমাকে ওটা দিন।
Yes.
Now, my lord, here this 28 January hearing, my lord, I was slightly factually incorrect. My lord, this 28 January hearing I did not attend because the notice was not served on me. The persons present, my lord, would indicate at page 108 of the papers, my lord, kindly sees the following persons attended the inquiry. I did not attend.
No, then you attended page 101, na?
101 is a notice.
Directed to appear for a hearing on 28th January.
My lord, please see 101. This notice was not served on me.
20th January, no, 25 notice.
Yes.
It was not given.
Not given to me.
Achha, very good. Then,
104, Lordship.
madam, we will hear you. Please take your seats. We are not running away. Yes.
Now, my lord, thereafter, this inquiry report, whatever.
So you did not appear in the hearing. It
Yes.
was not intimated you. Now, page 104 is a letter to
addressed to my advocate.
That please find a copy of the order of hearing 28. So that order was communicated to you.
Yes.
Where is that order?
And that order is 106.
106. Now, after this order was communicated,
just one thing I want to show from 107. Is the preliminary investigation report was given by DI in October 23, not disclosed to me, in which the inquiry team opined that Sri Mishra is personally responsible. This is absolutely close to paragraph 2.
What form you are reading?
Paragraph 2, 107.
Yes.
For the situation of turmoil prevailing in the school, and he has failed miserably. After this, what inquiry am I to attend? This is absolutely close.
Follow.
2, paragraph 2.
Yes, read it.
The preliminary investigation report was given by the DI in October 23. In which the inquiry...
On the basis of which 12th of December 23 memo was issued.
Yes. 12th of December 23 memo, if your lordship kindly falls back to 12th of December, that document, if your
9th
lordship...
of October 23.
Yes, 9th October 23, on the basis of that. Now, thereafter, page 107.
No, we didn't use what is a personally responsible?
Yes, the preliminary investigation report was given by the DI in October, in which the inquiry team opined that Sri Mishra is personally responsible for the situation of turmoil prevailing in the school, and he has failed miserably to foster an environment conducive to the learning atmosphere of the school. This a show cause was served in December 23. He has responded by 642 pages. Considering the reply, the authority of the board was pleased to issue a letter in March 24 for audit by an enlisted auditor, since the matter involved the allegation of defalcation of funds of the school, and such a report would have enabled the board to match and verify the responses of the show cause. Later, a reminder of the same was also issued. The DI requested the concerned auditor to probe the defalcation of funds as alleged. Meanwhile, the order of the Honorable Court directed DI to act expeditiously to enable the board to consider the reply to the show cause. But this order is in the writ petition carried by my learned friends, subject to correction. The board sent another reminder to the DI for an audit report and conclusive report in June, to which he replied that the audit report could not be performed due to the non-cooperation of the school authority. The board again sent letters to the DI and the president to ensure completion. The board sent another reminder. The Honorable Court in its order dated has directed the board to take a decision regarding the initiation of proceedings against Mishro within a fortnight from the date of issuance of the order. The matter was placed.
This was another order, 13 January.
Yes, those orders are part of the supplementary affidavit. I'll show. The matter was duly considered, and the secretary of the board was pleased to fix a hearing on 28 June. The following persons attended. Sri Pradeep Mishra was absent on the date of hearing. Please see, it is recorded. Now, these findings, the DIV school has submitted 2 letters through his authorized representatives, etc., and other addressed directly to the president. The first letter of the concerned DI has clearly outlined the fact that the special audit of job could not be completed within the stipulated time frame due to the non-cooperation of D. Kundu and Associates, the audit firm engaged for the purpose, and has recommended action against the said firm for its dissatisfactory performance. The DI has also requested Joint Director of Audit to take measures at the earliest, either to appoint an enlisted auditor or provide the list of enlisted auditors to enable the DI to appoint one of them and complete the said audit. The second letter dated this has informed this office of the letter dated this as mentioned, and also states that the school is presently running under an administrator, and has again reiterated the fact that the school audit could not be completed due to the non-cooperation of the audit firm. Sri Mishra has already retired on 30th June 24. The Secretary Board, after taking a hearing on the matter, placed the following proposals for the approval of the undersigned. The board waited for the audit report in order to proceed without any doubt in the initiation of the proceedings against Sri Mishra in the present situation. However, in the present situation, disciplinary proceedings may be initiated since the charges seem to be grave nature. Milord, kindly sees the discordance. The board waited for the audit report of the school in order to proceed without any doubt in the initiation of disciplinary proceedings against Pradeep Mishra. Then the Commissioner of School Education may be requested to grant permission to initiate disciplinary proceedings against Mishra since he has already retired. The Commissioner may be requested to facilitate the audit by nominating this. The Honorable Court may be apprised. Hence, the undersigned empowered under these rules hereby concurs with the proposals of the Secretary WBBSE and directs the following, that there is provided there is no contrary order, then this proposal was concurred by the Honorable President of the Board. The 4 things recorded in page 109, those 4 things have been concurred. And thereafter, when this is dated 28th of January 2025, thereafter the matter was pending consideration in this Honorable Court. Ultimately, at page 111, on 9 June 2025, a mechanical sanction has been accorded.
Why you are not filing an independent writ petition?
I am, yes, I can. But I am always, appeal is the carriage of the proceedings.
No, what has been decided in the appeal?
What
has not decided anything?
The only thing is, relegating me to a disciplinary proceeding, which is per se, on the basis of closed-minded facts.
We will mention that. We will say that the order will not prejudice you from any manner from taking all the grounds which are which you are arguing before us.
And my lord, additionally, I only want to make this submission, my lord. If my terminal
Provisional
benefits,
pension.
provisional pension and other benefits may kindly be
That is
extended.
also your right. We will record that. What more we can do for you, Mr. Bhattacharya?
To set aside the entire thing because non-disclosure of documents.
We had the jurisdiction to do so, we could have done. But I have no jurisdiction. We have no jurisdiction. You are in judicial review against an order
Of the appeal, of the
in
trial.
which an order has been passed. Oh, this has been done, so nothing more is required to be done. See the trial.
I completely bow down. I cannot, but will not kindly visualize will not the nature. Just because will not this entire thing is triggered by the initiation of this proceeding, will not the court was invited to give directions to the authorities. The court, the Honorable High Court was invited to give directions to the authorities, will not to expedite the process when the process.
Where is that order?
Yes. Yes. Please see.
That
Supplementary
order you
affidavit.
have not challenged. You should have come at that
7th
time.
April. 7th.
I was telling Mr. Kundu.
7th April.
Page.
Page 20 of the supplement.
20.
You are the school.
And I am pitted against very big
Mr.
question.
Bhattacharya, certain guardians came with an allegation that there is a defalcation of money or such and such committed by the headmaster. But the authority is not taking any decision. Challenging this inaction, they came. Court says that already permission has been granted, so I shall not intervene.
Court directed the DI to inquire into this matter. Allegation. Inquiry was submitted. The learned advocate appearing on behalf of the appellant also present and handed over everything. All sequence.
Please place the letter order of 7th April 2020.
Yes. 7th April 2025. Yes.
Page 20.
Yes. I am pleased. In terms of the order dated, that is page 20 of the supplementary affidavit. My Lord Justice Charisma.
Yes.
In terms of the order dated, this a memo dated 26th March issued by the Assistant Secretary is placed. It does not appear that the Secretary Education Department has taken any decision regarding granting permission to the board to initiate disciplinary proceedings against respondent number 9. On perusal of the memo, it appears that apart from other materials, Assistant Secretary has requested the President Board to forward draft charges framed against the headmaster of the school for taking decision whether approval is to be granted by the Education Department or not. For better understanding, Rule 5.3 is quoted. 5.3 in its entirety upon being quoted, it has been provided in the second proviso that in case of retired teacher and non-teaching, disciplinary proceedings may, with the approval of the government, be instituted within 3 years from the date of retirement if misconduct becomes known to the board after retirement. There is also a catch there.
No, kindly come to page 22, Mr.
Yes, on mere reading of the second proviso, that a formal approval is required to be given by the government in the event.
Yes, so ultimately directed. However, the board has not forwarded preliminary report and other materials which are available before the board related to provision.
Your Lordship is ready.
Forwarded. So that was forwarded.
And after that, this approval was granted.
That approval was granted. That
on 9th of June, page 111.
Page 111. You have a good case to go before the writ court and set aside the entire proceeding. That audit report was wanted without waiting for the audit report and thinking that the auditor is also under your guard. How could the board take this decision of initiation? Ground the present appeal.
Only this way, the provisional part, the pension part.
Provisional part we will observe.
DI
on a direction on him.
Yes, Mr. Chattopadhyay.
Entitled to as per last draw.
Nothing. Gratuity the farm.
Retirement.
Provisional pension to pabe. Petition has to respond.
Yes. Mr. Bhattacharya, you are insisting us to pass order for granting of provisional pension. Provisional pension is granted when? During pendency of the judicial proceedings and pendency of the disciplinary proceedings. Whether this decision to grant permission is bad or not, you can challenge. But if you take provisional pension,
That is wholly without prejudice to any right. Today I'm starving. Kindly visualize.
Permission to
I'm
initiate proceedings.
grateful. Exactly, your lordship is 100%. I cannot stand. Your lordship is correct. If I today accept provisional, that means my challenge to the other thing goes because I have accepted provisional. Today, a person has to sustain also.
That means
So as per my my lord, instruction, my lord, audit has been completed, and in the audit, my lord,
Whatever it may be, charge sheet has been
no, my
filed.
lord, that my lord, the board
And I don't have the instruction at this moment.
If charge sheet, the court recorded that it appears that the in view of grantor permitting the concerned to initiate proceedings against the respondent, it appears that grievance stands given. Where is that page 101? Na?
Yes. তুই ঠান্ডা এখন ছাড় এখন ভাবতে পারছি ছাড়ে চলে যাও ছাড়ে কেউ আছে এখানে
ওর সাবমিশনটা রিপোর্ট করে দিতে পারি।
ওর যে বক্তব্য দেখে মনে হচ্ছে যে decision to grant permission he will challenge.
Exactly.
Non-furnishing of a preliminary report, non-furnishing of the audit report. In absence of the audit report, they have taken this.
my lord, even if he is not entitled for retirement benefits, my lord, because two, my lord, FIR has been pending against him, my lord, and as per DCRB rules, my lord, if any judicial proceedings and
Then
criminal,
no provisional pension.
he is only entitled for provisional
that is
pension.
only-
These are statements from the bar. No criminal proceeding is pending against me.
So, Mr.
Lodging of an FIR is not criminal proceeding.
Mr. Vajraji, my brother has told you that
Yes.
if you accept provisional pension, you will be sanctifying the initiation of proceeding. What is your answer to that?
I look at it,
We can do this much for you. We can say that Mr. Chattopadhyay, upon instruction, has told us that steps are being taken for releasing provisional pension in your favor.
Releasing, terminal benefits, whatever legally terminal benefits, whatever he is entitled to. At least I am entitled to my own contribution.
Yes.
I am entitled to my own, irrespective of anything. Whatever little that
Provident.
there, my own contribution to Provident Fund does not stand in the way.
Provident fund and
Very good. If you insist, we will pass that order that they will take steps for granting provisional pension.
A provisional pension part, let me agitate there. Even if I accept, that would be without prejudice.
Also, the present, huh?
That would be without prejudice, assuming it is released in my favor. Well, I leave it to your lordship, but definitely a person cannot starve. You cannot be forced to attend an inquiry without subsistence.
We will say Mr. Chattopadhyay's instruction is they will pay provisional pension and other legal dues in accordance with law within a specified period, and we will say that he would be at liberty to accept the same without prejudice to his rights. The present appeal has been preferred, challenging an order dated No, that.
Analogous, right. In the event it is not called on item 11, kindly makes it not this week, my lord. In the
But
event
the
it is.
appellant,
Yes.
item number
11. But Mrs. Mojumdar is for the respondent. I proceed here tomorrow.
My lord, item 3 is passed over.
Not
Let,
item 11 টা not this week করে দিও।
my lord, and item 3 is passed over.
Yes.
Kindly let it be taken next week.
Why next week? Come tomorrow.
My lord, I have some
It was
difficulty.
that, matter regarding
300 marks in the.
What can we do?
What can be done, my lord? I said, your lordship, the verification process has started. My lord, I have not been called for verification because in the first phase of verification, I am 1 mark short. So, my lord, this verification will take some time. After that, my lord, if the ratio is not maintained, your lordship knows according to a particular ratio, candidates are called. If the ratio is not maintained, thereafter second phase verification will be conducted. I am 1 mark short. So in second phase, I will be called and I will be rejected because I do not have those 300 marks. So your lordship, the immediate urgency, my lord, I must say, there is no, but your lordship can take up these matters any day, my lord, immediate. There is no urgency, my lord, as of date.
No, Mr. We can dispose of the matter.
My lord, dispose of will, my lord,
Upon dismissing.
My lord, if your lordship dispose it of, but the issue single bench order remains that I am not eligible, my lord.
Yes, yes.
That will, when I will be called for verification, I will be straightway rejected. Then again for the same.
Then we will say there is no scope for interim order. You file your paper books. We will hear the appeal.
My lord, affidavits have been in the stay application. Your lordship has called for affidavits.
There is no scope for issuance of any interim order because your entitlement is not
finally done. It will be finally decided. There is no scope for interim order.
There is no scope because 240, 300, whether it can be liberalized or do, that is an issue to be finally decided.
Only thing finally, my lord, your lordship can give us a direction. That for that stay application has to be disposed of. Your lordship can give us a direction paper book. Only humble prayer, my lord. My lord, liberty may be given if I am being called so that I may mention and the matter may be taken up. Otherwise, paper book, hearing, I will never get the matter be heard, my lord. Only liberty if the urgency arises, I may
No,
approach.
we will say there is no scope for issuance of any interim order at this stage.
No interim order.
No interim order that at this stage.
Yes,
so if such situation arises, come with an application.
My lord, after paper book, my lord, only one liberty may be given to mention before your lordship. That will do, my lord.
আচ্ছা ঠিক আছে লিখে দাও তাহলে upon hearing the learned advocates the present appeal has been preferred challenging the judgment dated such and such to understand. Suppose you are called in the second verification.
I will be rejected.
Suppose you are called. If you are rejected, that issue you want to keep alive by mentioning the appeal so that it can be decided.
No, my lord.
That is your idea.
Immediately, when I will be called for verification, there will be a gap window. I will get a window of at least 7 days because they will publish a notice that so-and-so candidate has been called for verification.
So if the rejection order will be issued, so you will bring that rejection order as a 2-hour notice And we want disposal of the appeal as to whether 240, 300 can
Yes,
be.
that is, I want
তাই
disposal.
তো বলতে তাও কষ্ট করে রেখে কি হবে
I
আবার
want-
আবার ডিসমিস করবে আবার তো
Kindly don't give a direction for paper.
upon hearing the
Responded.
না কিছু তো শুনবেই নিশ্চয়ই 4টে অবধি। 4টে তো কি করবে? 4টের সময় তো অন্য
Yeah, Mr. Sharda, you have concluded, you want to,
I have not yet concluded.
in reply you submitted after the.
I have not concluded.
You have not concluded your reply. Anything else you want to serve?
Because I have not yet sought to distinguish the judgments relied upon by the parties.
Yes.
And before that, just nutshell the brief facts, possibly my lord record. Your lordship knows, my lord, vacancies of.
Just one. আমার ফাইলটা কোথায়? যেটা আমার চেম্বার থেকে এসেছিল। না না আমি একটা বাঁধা ছিল তো এটার সাথে এটা না এটা আমার চেম্বার থেকে এসছে।
Facts. Vacancies of fair price shop and distributors are under challenge. Challenged by the existing distributors and.
Just one moment, my brother has got. এইটা তো MAT 1544 এটা তো আছে।
Of fair price shop and distributors are challenged by the existing distributors and dealers in numbers of repetitions. Subject matter of challenge is that the vacancies has been notified under 2013 control order. The issue is that after coming into force National Food Security Act, which has came into force subsequent to 2013 state control order, Central has promulgated a new control order, that is by law 2015 Public Distribution Control Order, Targeted Public Control Order. Targeted Public Distribution Control Order says 2001 Central Control Order repealed. Our case is that the moment 2001 Central Control Order has been repealed,
no process can be done.
Because 2013 State Control Order has been framed under 2001 Control Order. So, my lord, all in the writ petitions, there was an interim order. Ultimately, my lord, all those writ petitions has been decided by single bench. 3 issues have been framed. Out of that, 2 issues have been framed in our favor.
One against you.
One against you. That is the issue whether 2001 control order can be given effect to or not. whether 2013 control order has become repugnant or not.
Yes.
Because there is clause 2 of 2015 control order says
if it is not implemented.
If it is not implemented. So, Honorable Division Bench confined the issue to that effect by the other coordinate bench, saying that the state will file a report
Before
saying
Justice Das.
why, whether it has been fully completed, whether it has been implemented or not, and if not, why. Your Lordship, kindly see the order dated 6th of August 2024. 24 no 25. 25. 24. 6th August 24 of the coordinate bench.
That is
the file. I can hand over also.
No. How many times you will hand over?
Yes.
6th August 2020. Shall you wait for this? এই ছোট্ট অর্ডার 6ই আগস্ট এখানেই আছে
It's a small order. Mr. Swanson for the may I read my
Yes.
Mr. Swanson for the appellants contended that the state has taken previously vacating stance with regard to full implementation of the National Food Security Act 2013 in the state. Before the Honorable Supreme Court, the state had pleaded that the act has been fully
this was
implemented.
passed by the coordinate bench in this appeal.
In this appeal. In this appeal.
No, then,
at the initial stage.
No, just one thing. By this, the two affidavits were called for. Two affidavits. Yes.
That's the order I'm reading. The state, before the Honorable Supreme Court, the state had pleaded that the act has been fully implemented. However, in the written submission placed before the Honorable Single Bench, the stance was that the act has not been fully implemented. Honorable Single Bench ought not to have relied on such submission, which runs counter to the stance taken by the state in the special petition pending before the Honorable Apex Court. Mr. Swanson, learned junior standing counsel, contended that the consistent stance in the state is that the act has not been fully implemented. However, steps are afoot to implement the act fully. In support of their submission, they refer to the observation in the impugned judgment that the Advocate General in collateral proceedings had informed the court that act has not been fully implemented. Appellants are fair price shop owners and MR distributors under the West Bengal Public Distribution System, Maintenance and Control Order 2013. Their principal grievance is the issuance of a vacancy notice under the State Control Order 2013 for appointment of new dealer under the said order. It is contended that the State Control Order 2013 is no longer in force as it stands superseded by National Food Security Act 2013 and the Control Order Targeted Public Distribution System 2015, framed thereunder. Pursuant to Section 1 of Targeted Public Distribution System Control Order 2015, inter alia State Public Distribution System Control Order so shall continue to have effect in any state which has not implemented National Food Security Act or is implemented the Act only in part. Appellants have sought to make out a case that the state has taken inconsistent and evasive stance in the various proceedings with regard to full implementation of the National Food Security Act 2013. To clarify the position, we call upon the Principal Secretary, Food and Supplies Department, Government of West Bengal to file affidavit disclosing whether the National Food Security Act 2013 has been fully implemented in the state or not, and if the same has not been done, the reason for its implementation in full. The affidavit shall be filed by 12th August 2024. response to the affidavit being so and so, interim order has been granted. But in response to this order, initially a report has been submitted. Subsequently, further direction has been given by the coordinate bench. A fresh report has also been submitted.
Two reports.
Two reports. We have filed, my lord, exception
to one report.
Both.
Covering both.
No. Two report, two exceptions.
Two exceptions.
Yes. May I give that?
September.
One report 13th August.
My lord.
Exception to it is on 9th September.
My lord.
And the second report is
supplementary report that is affirmed on 10th of March 2025. An exception to that affirmed on 10th of March, supplementary affidavit. And exception to that report is, my lord, on April 2025.
Yes.
Well, in that
first report is of 13th August 2024.
My, you could kindly take up this report.
You are showing us first report then?
Yes. Report in the form of affidavit?
Yes.
But kindly, if you lordship, kindly go through this report. I have already shown to your lordship. I don't want to.
Supplementary report. The second report, like the first report, main report, 13th. It's exception. দুটোই exception দিয়েছে। রিপোর্ট দুটো নেই। একটা কাজ করো না, এটা এখানে রেখে দাও।
তুমি কত পেপার বানাবে? তুমি কি ফার্স্ট রিপোর্টটা পেয়েছো?
দুটো এক্সেপশন এসছে।
ও
Go through these reports. I have already placed. Mr. Bandhavate already placed. It will appear they, with no uncertain term, says that it has been implemented except section 12 of the National Food Security Act. If you kindly go through 2-3 paragraphs. Kindly come to my lord.
What was the proviso? If not fully implemented,
then
or if implemented
partly, then previous control order may continue. Our case is that it has fully been implemented. The twofold submission is that in a other proceedings, duration scheme, Lieutenant Advocate General submitted before the Honorable Division Bench, Coordinate Bench, Justice Dash, that we have not fully implemented. Following such submissions, although duration scheme has been directed, my lord, washed and set aside, rather ultra vires. But so far this point is concerned, whether 2013 control order is in force or it has become redundant by virtue of the supersession. That point was left open.
NFS Act has been declared ultra virus.
No.
You say?
Just I'm telling you. Subsequently, state government framed a scheme, duration scheme.
Yes. Which was
invoking the provisions of 2013 control order. Virus of such duration scheme was under challenge. Matter went up to the division bench. Division bench declared duration scheme as ultra virus to the Constitution of India. In that proceedings, we have also taken a plea that duration scheme has been declared under a redundant law, that is 2013 state control order. So far, this part of submission is concerned, that has not been gone through by the Honorable Division Bench, Coordinate Bench, holding that during the submissions, Learned Advocate General submitted before the court, it has not been fully implemented. We are believing the statement of the Learned Advocate General. Since the Dwaresham scheme has been declared ultra-vires, state preferred a SLP. In the SLP, in paragraph 54 ground R, it has been stated that the Honorable Division Bench wrongly recorded the submission of Learned Advocate General that it has not fully implemented. We have handed over to your Lordship that also. So 2 stands.
This one, you're given.
Yes, yes.
Yes.
So before the Honorable Supreme Court, they have not filed any modification or clarification. Their stand is still there. We have fully implemented. That is the observation in the interim order by the coordinate bench also. Double stand. Yes. Accordingly, the coordinate bench directed at the time of passing interim order to file a report stating therein whether it has fully been implemented or not.
Supreme Court, it is still pending.
Still pending.
Yes.
Now the affidavit come from the state, filed affirmed by the Principal Secretary. If you actually kindly take up the first report. I am not going through the entire thing because it has been placed before Lordship, myself also Learned Standing Senior Counsel. Kindly turn to paragraph 2, page 2. Paragraph 3. Kindly take note of just one line. The reforms prescribed under the different provisions of the National Food Security Act 2013 and their implementation by the government of West Bengal are delineated herein below. Kindly read, my lord, all the section 12.2 and all under section 12. Almost everywhere they have stated that we have fully implemented, except, my lord, the reforms.
Except?
Reforms. That is section 12. I shall read to your lordship. So reforms is a continuous process. Implementation is something different. After even implementation, reforms will continue for betterment of the public distribution system. I am just giving the references, my lord. Implementation means setting up of fair price shops, distributorship, specification of the ration consumers, eligible households, distribution of ration articles to them, fixing of quota, allotment dates. These are all implementation. And reforms part says how and which manner it can be upgraded. That is to say, distribution through EPOS machine by thumb impression. These are all reforms. So reforms cannot be taken note of that it has not been implemented. People also kindly take note what is their statement in the report. They says we have implemented. But only section 12 has not been. Kindly take note of my section 12 just for a moment. If you have to kindly take up my stay application. Section 12, National Food Security. Now, kindly take note of my stay application.
Yes.
213 page.
209.
Well, up to 11, all our implementation kindly come to section 12. At page 213, this is the National Food Security Act, which they have quoted in their report. Page 213. Kindly read, my lord, chapter 5, reforms in targeted public distribution system. What it says, 12. The first sentence, the central and state government shall endeavor to progressively undertake necessary reforms in the targeted public distribution system in consonance with the role emphasized for this in this act. Right-hand side, reforms in targeted public distribution. What is the meaning of reforms, my lord?
Reforms is a continuous
process. So implementation cannot be withheld for the part of reforms. It will continue, never ending. I have also placed before Lordship the definition of reforms from the Black Law Dictionary and other dictionaries also. It says it is a continuous process. For upgradation of any particular thing, it will continue. And that is their case also in the report.
The Black's Law Dictionary.
That 2-3 dictionary.
Yeah,
I shall again hand over if
Yeah,
necessary. Now, Your Lordship, kindly take up our reply, rather exception, second exception. So for the
No, this paragraph 3, what you are saying.
Paragraph 3, kindly read, my lord.
First report which you were placing.
Yes, kindly take note of paragraph 3. The reforms prescribed under the different provisions of the National Food Security Act and their implementation by the government of West Bengal are delineated here below. Section 12(2)(a), doorstep delivery of food grains to the targeted public distribution system. Right hand side, answer.
Except section 12?
Everything has been implemented.
So this section 12 pertains to reforms, which is a continuous process, which will ever continue.
This is our specific submission. I'm grateful to Lordship. Kindly take next page, page 3.
These are the works which are going on admittedly by the state, and as such state says
Your Lordship, if you Lordship kindly go through, I am not reading. Or entire report says we have implemented, but reforms part is still to be implemented by the state. That's a specific report. Now, Your Lordship, kindly take up my exception to the supplementary report. I am not going through the first one. Exception to the supplementary report.
No, in the first extension, you want to.
I have categorically stated, but I have annexed the documents in my second report, second exception.
12 of the ঠিক আছে reforms, page 4, section 16. Technique of the commission or section 24, responsibility of the GM.
সেটা তুমি একে জিজ্ঞেস করো,
ওর নিচে একটা দেখুন,
স্টেট কে জিজ্ঞেস করো।
নেপালটা দেখুন,
But evaluation got valid except.
এটা তো সাবস্ট্যান্টিভ তাহলে হয়ে যাচ্ছে।
But I am not.
24 রিফর্মদের মধ্যে আসছে না।
I am not also banking upon their report. I am banking upon the order.
Mr. Sarai, my brother has pointed out.
Yes.
Kindly come to the first report, internal page 4.
Page 4.
As regards section 16, they say that State Food Commission has been constituted.
Now, right hand side answer. Can you take the answer? The State Food Commission has already been constituted. So they are admitting.
No, that section 16 implementation is over.
Yes. Yes.
We will, yes.
That is their case.
Yes. And section 24 also.
Everything I am submitting, everything has been done, or except reforms part. That will appear from our exception, from the document issued by the director and the principal secretary. Kindly take up my exception to the supplementary report.
We will take up. Saying what? Saying what?
It has been implemented in 2016. 100%. That's their document. Needless to go through this report. Report also says.
We have understood is that in the guise of section 12 reforms which are continuing, they are trying to make out a case that that act has been fully
not implemented.
No, not implemented.
But kindly come to page 4 of the report. Just third column.
First report. First report.
This is their report.
Page 4.
Cash transaction, third column, has been done. Each and every paragraph, right hand side is the answer. Kindly read. Everything has been done. The State Food Commission has already been constituted in 2017. The state government implements other welfare scheme. Next page, page 5. All have been done. Kindly turn to page 6, middle portion, right hand side answer. The state government has a well-established mechanism for the issue of ration cards to the eligible and willing people of the state. And the state government provides food grains to the beneficiaries having ration cards at subsidized rates under the NFSA. Therefore, there is no necessity for payment of food security allowance. Fully implemented.
All right. Now you are showing us exception to the second. Page.
Have a look, Portman.
Yes.
Page 11 first. Straight away come. This is their document. Director, District Distribution, Procurement and Supply, the second highest authority of the Food and Supplies Department. This is 22nd of January 2016.
Page
11. From director to all district controllers. Right hand, left hand side top. Guideline on National Food Security Act and Rajya Khadya Suraksha Yojana, RKSOY. Enclosed, please find here with the guideline on implementation of National Food Security Act and Rajya Khadya Suraksha Yojana, going to be implemented with effect from 27th January 2016. Throughout West Bengal.
Yes.
Next page, 12. Implementation of National Food Security Act will commence in all over the state of West Bengal, 27 January 2016.
Yes.
Who has signed it? Kindly come to page 21. Page
No,
20.
this is their will comments. Will comments from 16.
This is part of
No, they are saying that it may have commenced, but it is not complete.
Kindly turn to page 21.
Yes.
27th of July 2019.
Yes.
Third paragraph. For successful implementation of PPOS machine, following points should be taken care of. Page 24 is the most important document. Page 24. And the next one. Kindly come to page 25. Need not go through the page 24. 25. This is Special Secretary issued on 15th October 2020. Fairprice shop automation had been introduced in December 2018 and full rollout was done so and so. The department had issued orders by so and so. 100% transactions through PPOS machine. The objective of a so and so 100%. Next part, page. Sending process when it will be completed. Kindly come to page 25. First line of page 25.
Implementation. Fully implemented. 100%.
Fully implemented.
fully implement বলছো না
Page 25. Department has issued orders in which 100% transaction through POS is made mandatory. Objective automation is to be. Objective
এটা থেকে বোঝানো যাচ্ছে
এটার জন্য to fulfill the objective guideline ও তৈরি। Page 25 says that to ensure 100% transaction through such and such guidelines have been issued.
And this guideline is also part and parcel of section 12. This is reforms part. I am on mainly, my lord, page 12.
Page 12?
12, which I have shown to your lordship. First paragraph. Implementation of National Food Security Act will commence in all over the state of West Bengal on 27 January 2016.
That could have been their policy, that it will be implemented from 16.
Yes. Anywhere they have stated it has not been implemented. Anywhere they have stated, not even in the report. Clubbing together the affidavit affirmed by the Principal Secretary before the Supreme Court. No uncertain terms, statement of learned Advocate General that it has not been fully implemented, wrongly recorded by the division bench. Vice versa, it has fully been implemented. Not a single line in any of the reports that it has not been implemented. Only reforms part.
Yes.
Implementation monitoring. Implementation section 24. Section 24. Last report section 24 যেটা ব্লক করে আছে section 24 state government implement other policies such and such implements
নিশ্চয় দেখে দাও এই
section
I will key off
implements এই section 24
Something else before the Supreme Court I could have understood.
No, that we have argued. We have taken note of that.
So,
Yes.
Staying from the bar, even not in a opposition, despite repeated direction of the learned single judge, no opposition has ever been filed by the state, saying that we have not implemented. No affidavit before the division bench, not even in the report. Report says section 12. Section 12 says reforms.
Yes.
And the learned single judge held, since the during the course in the notes of argument, it has been submitted on behalf of the state that it has not been fully implemented. I am accepting. Rather, before a coordinate bench, subsequent to filing of the SLP, this another matter went up to. And the same coordinate bench, presided over by Justice Das, as his lordship then was, criticized the state and passed an interim order. Petition Dipti Kumar China, I have handed over the copy of the interim order. The learned single judge in that case.
Let us go one by one. You finish it off on this, then you. Anything else you want to show from the everyday second exception? You have shown us pages 12 to 25.
Yes.
Yes.
Order.
Judge. Supplementary.
Yes, Dipti China, what do you want to say? You want to show us?
Yes, I have already handed over. The justice coordinate bench presided over by Justice Das, as his lordship knows, I have submitted before lordship in duration scheme. Although the scheme has
No,
been
this is the single bench. You are telling us division.
division bench also there.
Hmm.
So আজকে এখানে আমার কাছে আছে।
Yes. What we
Just before that, my lord, I have submitted before lordship the duration scheme. We have taken the same point that you cannot issue
under
duration
that
scheme
order.
invoking 2030. In other points, duration scheme have been declared ultra vires. But in respect of our
This was left aside in view of their submission.
now SLP everything. Subsequently, another matter was moved before the learned single judge. It was also contended on behalf of the state that it has fully been implemented. Now that writ petitioners filed an appeal before the same bench of Justice Dash, as his lordship there was. That is the judge order, interim order of the division. Kindly take note of. Clamor.
Now, what was the subject matter in the Dipti?
Vacancy.
Same which you have.
Yes. Kindly take note of division bench order dated 3rd February. Have you got it?
This is after disposal of the first matter declaring ultra vires.
Pendency of the Supreme Court.
Single bench order.
That was placed before the honorable division bench so far the SLP is concerned.
Internal page 4, second paragraph.
Yes. Clamor.
Here, remember, piecemeal হচ্ছে আর থাকেনি।
Have you got my lord?
Yes. So page that clamor. Yes,
Clamor.
That criticism portion line.
Just clamor. There is a clamor. আচ্ছা চিন্তা তো কথা আছে।
You yes, you may take our একটা দাও না।
Just kindly paragraph. Your lordship has already marked page 4, second paragraph. Page 4, take it, second paragraph. Is subsequent to the judgment in duration.
No, there was a clamor in respect of the legality of the impugned action in view of coming into effect of central control. So where is the criticism?
No,
Mr.
criticism I am saying before option. The same bench held previously that it has not been fully implemented.
Show us that line in the first order where it was virus
Can you take up the duration judgment?
Duration
I have handed over. আছে কেন থাকবে?
আচ্ছা we have
কেন থাকবে?
আব্দুল মাজিদ।
শেখ আব্দুল মাজিদ কেন নেই করছো কেন তোমরা? কেন থাকবে না? দেখালে
শেখ আব্দুল মাজিদ।
My lord. Just that portion. Since learned advocate আছে দেখুন High Court order division. Just kindly take note of paragraph page 35. Page 30. Third paragraph. Learned Advocate General submits that taking into consideration the mechanism which has been provided in National Food Security Act and the Central Control Act 2015, like monitoring, etc., the NFSA Act has not yet been implemented in full in the state. It is submitted by Mr. Call Learned so-and-so. When Learned Advocate General, being the highest officer of the state and supposed to be in know of the facts in submitting that NFS Act has not yet been implemented in full in the state, in absence of a positive affirmance in the pleadings, in the petition by the petitioner appellant, we cannot simply deny the assertion made by the Learned Advocate General. Clause 2, Central Court 2015 clearly negated the contention raised by Mr. Paul Learned Senior Counsel appearing for the absence. It cannot be held that the Rural Controller 2013 are non-existent in view of the suppression of central supersession of controller sons. Now, Your Lordship, kindly take up the SLP.
Ground.
Yes. Subsequent to that, or the entire SLP
No.
Page 54 ground art.
Yes, yes, we have got it.
Because the Honorable High Court erred in recording that it had been submitted by the Learned Advocate General that the NFSA had not been fully implemented in the state.
Yes.
So far, this part is concerned, these are my submissions, that it has fully been implemented. And that's the only case made out by the Learned Single Judge in respect of the issues framed by me. And division bench confined only to that point.
Then what was the answer of the single judge to such argument of yours? In the order, in the judgment
can I take up my impugn order?
Paragraph 26.
Can I take up the impugn order?
Learned single judge simply accepted that contention.
Notes of submission.
On the basis of the notes of submission.
And that has not been handed over to us till today. Admittedly, we have also not handed over our notes of submission, but we are not. There is no affidavit in opposition on behalf of the state, despite repeated.
Show us, tell us that paragraph of the impugn judge.
Oh, no. Page 343. ঠিক আছে ঠিক আছে Shetara Begum, first item.
Shetarate. That is filed by the
private respondent.
Private respondent. আচ্ছা আচ্ছা তো ওই ক্রস অ্যাপিলের ফাইল আছে তো আমাদের কাছে
Yes. Kindly take up page 343 of the stay application. Only one paragraph.
343.
Inner page 15 of the judgment, impugn judgment. Paragraph 17 of the impugn judgment.
No, the paragraph said in it deciding the first issue.
No. Paragraph 7. Kindly turn to page 340. Paragraph 17. At the outset. This is the only conclusion of the Learned Single Judge. So far, implementation, partly implementation, or not implementation. At page 343.
Yes.
At the outset, the veracity and effect of ground taken in the SLP pending before the Honorable Supreme Court, we have placed before the same.
Yes, yes.
Being ground number R at page 54 cannot be decided in the present writ petition. Take note of. However, it is pertinent to note that Mr. Shishano Bandhavadhyay, Learned Junior Standing Counsel for State of West Bengal, in his written notes of arguments, has categorically stated that certain provisions of National Security Act has not been fully implemented in the State of West Bengal. Such being the position, kindly take note of. This is the only findings. Such being the position, meaning thereby, since the Learned Junior Standing Counsel in his notes of submission recorded that it has not been fully implemented, I am satisfied about the same. Whatever report, whatever evidence filed before the Honorable Supreme Court.
Yes.
It is not the case that we have not placed before the Learned Single Judge so far the episode conduct of the state before the Honorable Supreme Court. That has been taken not by the coordinate bench at the time of passing interim order.
Yes.
So the only issue involved in this appeal, as I understood, my lord, whether implemented or not. I have tried my level best to show before your lordship that National Food Security Act has fully been implemented. It is their case also. Not only in the report, not only in the supplementary report, but also before the Honorable Supreme Court.
Very good. Then, Mr. Sharda, you tell us something about the cross appeal.
No,
As
so far the
because
judgment relied by Mr. Shishana Bandyopadhyay.
that is no appeal is required to be preferred.
That is first part and section 24 of the General Causes Act. Will also allow me to.
Yes. So so far as the judgments on the said issue you deal later, first say 24, what you have to say?
General Causes Act. Can you take note of General Causes Act? But General Causes Act actually has not been placed before lordship by Mr. Bandyopadhyay. But he relied upon judgment.
He has not said, but the learned singer just discussed this.
Yes.
So I had shown the judgment in that it was quoted.
Mr. Bandyopadhyay placed before lordship judgment.
Yes, yes.
Where the section 25 has been quoted.
কেন আমি আর দেখাই এই ওই দুটো দিয়ে ওই দুটো দিয়ে
কেন দেখাস না
ওই দুটো দিয়ে ওইটা দেখাই ওই দুটো দেখতে ওই দুটো দিয়ে দিই
Yes.
এই ট্যাগ দিয়ে
That is quoted in the order. We have got it.
I'm handing over.
Section 24.
Yes.
Yes.
Sure. May I read, my lord?
Excellent.
Can you read, my lord?
General Clause Act,
Your lordship has also got the
Para 27.
General Clause Act.
Order, etc. issues under enactment repealed and reenacted. Where any central act or regulation is, after the commencement of this act, repealed and reenacted with or without modification, then unless it is otherwise expressly provided, any appointment, notification, order, scheme, rule, form or bylaw made or issued under the repealed act or regulation shall, so far it is not inconsistent, kindly take note of, with the provisions of reenacted continue in force and be deemed to have been made or issued under the provisions of reenacted unless and until it is superseded by the appointment. Kindly take note of. In our case, there is a specific word in 2015 control order superseded by 2001. Unless it is superseded, section 24. Unless it is superseded by any appointment, notification, order, scheme, rule, form, or bylaw made or issued under the provisions of reenacted, and when any central act or regulation which by a notification so and so. When it is not superseded, kindly take note of section 2015, controller 2015. By superseding 2001.
Yes.
Section 24 strengthening our case of General Causes Act. If it is superseded, nothing remains.
Yes.
Another documents.
Now, what was the finding of the court on that issue? Para 28.
Yes. 43. Kindly come to paragraph 28. last part, third line. Unless and until it is superseded by any appointment so and so. In Hiroxin so and so, Hiroxin so and so, paragraph 30. Bearing in mind the aforesaid the Controller 2001 not being superseded by TPTS Controller so and so, since the state of West Bengal has not implemented the National Food Security Act fully, the state controller will to continue to operate until and unless the circumstances so arises upon full implementation of the National Food Security Act, which would make the central controller to be superseded. Till such period, the central controller 2001 is not superseded, the state controller 2000 will be cooperative. The targeted public distribution controller 2015 allow the central to be effected, which is genesis of such controller in the state of where so and so has not been fully implemented. So same ultimate notes of submission, I cannot disbelieve. Ultimate submission of the London Advocate General, I cannot disbelieve. Before the coordinate bench, London Advocate General not fully implemented. Before the Supreme Court, fully implemented. Before the London single bench, again, not fully implemented. Not by any affidavit, only notes of submission after conclusion of the hearing.
Yes. This is one point.
Yes.
Section.
So, the conclusion part is also the same point, not implemented.
Plinth of the judgment was on the basis of the contention of the state, and which is contrary to what has been said in this.
I'm grateful. Now the judgment which has been relied upon.
Yes.
Now, past judgment, so far, my lord, this part of the submission of Mr. Bandhopadhyay is concerned, whether there is a need to file any appeal or not.
হ্যাঁ ওইটা দড়ি দিয়ে বাঁধা জাজমেন্টের ইয়েটা দাও হ্যাঁ
ওইটা
দিয়ে ফেলবো এইটাকে
এটা পরে but before that only
এটা দিয়ে ওটা বাঁধো আর J1 করে রাখো ওটার সাথে
But your lordship, before going to the judgment, another argument has been advanced by Mr. Bandhopadhyay, the GSR 800.
Yes, sir.
This is a notification of New Delhi, 9th June 1978. Handed over to your lordship. I can hand over again copy.
No, আমাদের কাছে আছে তো ওই what is the date? 9 June?
9 June 1978. Copy has been handed over, but it is not so legible. I can hand over the typed copy. It has been typed copy.
No, he must have given it to us.
Yes, that has been handed over by Mr. Bandhopadhyay. I can hand over the original copy and typed copy also.
No.
This is the typed copy and this is the original notification. Both I am handing over because this is not legible. It is legible. According to them, it is also the submission that there is no requirement of 2001 central control order. There is no requirement of 2015 control order, which have been done by the state at the time of framing 2003, 2013 and 2024 control order. Relying section 3, section 5 as also central control order. It is a mistake. From the bar, it is the case made out by, sought to be made out by the state that although at the time of issuing 2003 first control order, we have categorically stated it is being done in exercise of the power under section 3, read with section 5 and central control order. There is no requirement. There is no requirement to exercise power under 2001 central control order. There are also submission 2013 when we have quoted 2001 control order. There was no requirement. Mistake. 2024 again they have quoted 2015 central control order. Their submission it is also mistake. Because GSR 1978 empowers the state government to monitor, control foodstuffs. Their further submission, section 3 itself gives the power. There is no requirement of
Five.
Section 3.
Section
Section 5 is the
3.
delegation. They can control, monitor any foodstuffs under Section 3, invoking Section 5 of the Essential Commodities Act. No central control order is required, separate central control is required. Because GSR 800 empowers them. My Lordship, kindly take note of GSR 800, 9th June 1978.
Yes.
May I read, my Lord? In exercise of power conferred by Section 5 of the Essential Commodities Act 1955, and in supersession of the order of Government of India in the late Ministry of Agriculture, dated 20th June 1972, the central government hereby directs that the power conferred on it by Section 1 of Section 3 of the Act to make orders to provide for the matters specified in clause A, B, C, D, E, F, H, I, Roman 2 and J of such subsection 2 thereof shall in relation to kindly take note foodstuffs to be exercisable also by a state government subject to the condition. Pausing for a moment. We are dealing with public distribution system. Section 5 empowers the state government by way of delegation. You may control also by framing rule in exercise of power under Section 3. But your control order must be in consonance with the central control order. It is only in respect of foodstuffs. Next, that such powers shall be exercised by the state government, subject to such directions, if any, as may be issued by the central government in its behalf. 2. That before making any order relating to any matter specified in the said clause A, C, or F, or in regard to distribution of disposal of foodstuffs, again take note of, not public distribution systems, to places outside
What
the
is
state
the
or in
difference?
regard.
What is the difference you are wanting?
Yes,
Foodstuff and
yes,
public
yes.
distribution? Yes.
Well, foodstuffs includes seeds oil, seeds, which is not a ration commodities, not coming under the public distribution system. All items
Are including seed oil.
Yes.
In foodstuff.
Yes.
Now this foodstuff term has been brought from which provision? Any control order?
Section 5, I shall show to you, Lordship. Section 5 and 2001 control order. Just kindly let us be completed. Outside the state, in regard to regulation or transport of any foodstuff under said clause, the state government shall also obtain the prior concurrence of the central government. Kindly take note of. If the state stand is that invoking 1978 notification, you are empowered to frame any state rule for implementation of National Food Security Act without taking help of 2015 central control order, then they have to take a prior concurrence from the central government. Let them show either 2003, 2013 or 2024, any concurrence has been obtained, because they have not proceeded on the basis of this. It is only from the board. Again, I shall show to your Lordship 2003 control order says, in exercise of the power under Section 3, read with 2001 central control order, not read with this one. 2013, in exercise of the power under Section 3, read with 2001. In 2024 also, when this matter is pending and going, hearing by your Lordship.
Now come to the foodstuffs. Foodstuff, what?
Yes, kindly come to 2001 control order first.
Yes.
Kindly take up my stay application.
Yes.
At page.
Yes.
146.
Yes.
But this is the first control order framed by the central government.
Yes, yes. You have showed us.
Kindly read up. GSR number so made page 146.
Yes, GSR.
GSR number so whereas the central government is of the opinion that it is necessary and expedient to so do for maintaining, supplying and securing availability and distribution of essential commodities under the public distribution system. Wheat, rice, even kerosene. public distribution system. Sugar. So 2001 meant for public distribution system. 2015 meant for public distribution system.
No, public distribution including foodstuff.
Absolutely. But for public distribution system, you have to invoke this provision. Section 5. For that, if you also kindly allow me to read my section 5 and 3. Because section 5 says, power is being delegated to the
Essential Commodities Act. Yes. 5, what you are showing?
Before that, section 3. Power of the central government to monitor, control, distribute essential commodities. Power to control production, supply, distribution of essential only by the central government. Now, section 5. This power has been vested only to the central government under section 3. Now, delegation at section 5.
Yes.
I am reading my lord. Delegation of powers.
Yes.
The central government may, by notified order, direct that the power to make order or issue notification, subsection 3, shall in relation to such matters and subject to such conditions, shall in relation to such matters. Matters mean public distribution system. Or such condition, if any, as may be specified in the direction, be exercised also by such state government. So, central government directly does not give delegation power to the state under section 5. A notification is to be issued by the central government, empowering the states to frame rule for monitoring and controlling essential commodities under section 3 in consonance with that notification. That is the notification of 2001 Central Control Order, which says you may deal with public distribution system by way of issuing a special control order in consonance with 2001 control order, subsequently in consonance with 2015 control order.
Very good. Yes.
Not 76.
Now
76
deal
foodstuffs.
with the judgments.
Mine.
Finished.
But past judgment relied on by learned senior standing counsel. It may be recorded junior standing counsel because at that material point of time he was not senior standing counsel.
Now it will be senior standing counsel.
Now, but at the time of placing, it may be recorded. Which one?
This notification came while I was arguing a matter with your lordship, Malad. There is Papia Ghoshal and Kavita something.
Then when did that notification come of senior standing?
Well, while I was arguing,
Main issue, my lord.
That one came while I was arguing that matter.
Yes.
Yes, concluded.
Please, Mr. Sarah, please.
My lord, 1998, volume 7 Supreme Court cases. The first judgment, 1999.
Right.
No, Mr. Bandyopadhyay.
97. 99. 99, volume 7 SCC has been relied on.
No, before that, kindly apprise us about one thing. The submission of Mr. Sengupta.
That I shall, because he has only relied upon yes, two judgments and renewal. Let I conclude his submission, because Mr. Sengupta has submitted only yes, 1999, volume 7 Supreme Court cases, page 435.
Yes.
But before dealing with all those judgments which has been relied by Mr. Bandyopadhyay, in regard to whether there is a need to prepare any appeal or cross appeal, my respectful submission of none the judgments are in related to mandamus appeal. These are all in respect of civil suits. The first judgment which has been relied on 1999 volume 7 SCC.
Just a moment. He relied upon 99 volume 7 SCC, 2004 volume 3 SCC, 98 volume 7 and 94 volume 2. All are on all.
No, one judgment is related to, my lord,
adverse findings.
No. section 24 of the
next thing.
but he has read on
You
let I
no, please tell us na that which are the judgments on the point that no appeal is required.
99.
This is one.
Yes.
Similar another judgment.
2004 volume 3.
2004 volume.
Volume three.
Yes.
This is all same
2004
point.
volume 3.
Then 98
Volume 7.
98 volume 7 same.
Same.
Right, Chintu?
And
94 volume 2 same.
that is what we are saying.
Yes.
He
And
relied upon
only other two judgment.
You so what is your reply to these judgments?
First submission would be my lord, all those 4 judgments has been delivered in civil suits, not in a intercourt mandamus appeal.
Principles are applicable.
I'm saying I'm giving the reference. Absolutely, principle is always acceptable. But the first case, 1990 volume 7. What happened, my lord, in this case? A suit has been filed by the plaintiff with 2 false pair. First pair for damage. What happened? Some goods have been seized by 2 police officers of Assam government. So suits have been filed against the Assam government and 2 police officers. So for the first schedule of pair is concerned, for damage, for reputation, prestige, etc. And BC prayer, schedule BC is for recovery of money, sale proceeds of goods. The civil court passed an order decreed in respect of B and C. So far the sale proceeds are concerned, holding that so far the reputation part is concerned, prestige is concerned, we are not going the same.
Yes.
Now the plaintiff preferred appeal, challenging the judgment, saying, I am entitled to get both the reliefs. The private respondent did not file any appeal. He support the judgment so far the second part is the first part is concerned.
Proceeds. Second
Proceeds, I'm getting. But during the course of hearing, he argued that 1 and 2 first prayer rightly has been rejected by the.
So in this case, there was no such argument advanced.
Yes. Yes.
And then
yes, if you also kindly go through the judgment he has relied upon.
Paragraph 21 to
24. Yes. And facts have been stated at paragraph 3, possibly, my lord.
Yes. Next.
Now, paragraph 2004, volume 3, Supreme Court cases.
Paragraph 35 he relied.
Yes. Our case is paragraph 37 at page 246. This is article 136.
2004 volume 3 SCC.
Yes.
Page 214.
My lord.
You are relying para
37.
37.
What is the ultimate conclusion of the Supreme Court? Or may I read, my lord?
You tell us at a gist now.
Yes.
You want to
kindly turn to page 247.
247, yes.
My lord. Last 2 lines of the paragraphs.
We do not think such explanation.
Condonation of delay. Ultimate conclusion, rejection for condonation of delay. It starts from paragraph 37. I will also kindly take note of. SLP has been dismissed on the ground of condonation of delay. You will also kindly take pen to go through the paragraph 37 entire. This is also under article 142. Kindly take note of.
No, why you are saying 142?
You will also kindly take note of paragraph 35.
That is
page 246.
This court being a court of plenary jurisdiction.
Yes. The ultimate conclusion of the Supreme Court, SLP is not maintainable since the explanation given regarding delay is not acceptable. What principle has been laid down by the Supreme Court?
But the observation carries
What is the observation? Findings kindly read. Dealing with the case, entire thing has been considered. What is the ratio of the case is to be taken note of by the court. Ratio says your appeal is not maintainable because it is barred by delay. An explanation given by you is not acceptable to the court. Then whatever I have considered, that is not the ratio of the judgment as I understood. The ratio says findings and order in portion.
Yes.
Court does not say, had there been no delay, I could have entertained your application. Court says there is delay, you have not provided reasonable opportunity, reasonable reasons, I am not accepting. The second judgment. Third one is, my lord, 1998, volume 7, Supreme Court cases. But kindly take note of page 327, paragraph 12, last 12 lines. 327.
Yes.
Kindly come to paragraph 12. Page 333. From bottom, after 12 lines from top. The sentence right-hand side starts, the rule enables. Have your lordship got my lord? Paragraph 12, page 333, from top, after 12 lines, right-hand side, sentence starts, the rule enables the appellant to pass any order, decree which ought to have been. Have your lordship got? Have your lordship got?
Oh, sorry. 98 volume 7. 98 volume 7.
Yes. 99.
27, paragraph 12.
Paragraph 12. Page 333. It's in online. 1998, volume 7, Supreme Court cases.
Oh, yes. Paragraph 12, yes.
Paragraph 12, if you also kindly take up after 12 lines, right-hand side sentence starts, the rule enables.
Yes.
The rule enables the appellant court to pass any order, decree which ought to have been passed. The general principle is that a decree is binding on the parties to it until it is set aside in appropriate proceedings. Ordinarily, kindly take note, ordinarily the appellant court must not vary or reserve a decree order in favor of a party who has not preferred any appeal, and this rule holds good notwithstanding order 41 rule 33 CPC. However, in exceptional cases, the rule enables the appellant's court to pass in favor of parties who have not filed any appeal. This is exceptional. Ordinarily, court should not. This judgment has been relied on behalf of the state. I should have relied in. This is an exceptional case. Taking in note, no opposition before the learned single judge, no opposition before the division bench, no averment in the two reports filed before the division bench in terms of the order of coordinate bench.
Next,
my lord, 1994.
For volume 2 SCC, page 40.
Now, this also deals with the normally exceptional. Paragraph 14. I am not reading. Paragraph 14 also says, last 4 lines, paragraph 14. Exceptional, ordinary. I am handing over, my lord.
We have.
Yes. Kindly take note, paragraph 14, last 4 lines.
94 to
volume 2 Supreme Court cases, page 41. Paragraph I'm reading.
Yes, you should.
Last 4 lines of same principle, paragraph 14.
While it is true that.
Yes. While it is true that since the power of derogative of the general principle that a party cannot avoid the effect of a decree against him without filing any appeal of cross exhaustion, and therefore the power has to be exercised with care and caution. It is also true that in an appropriate case, the appellate court can. But this is the exception. not normally.
Yes.
The next judgment Penal Causes Act 2002 Volume 3 Supreme Court Cases, page 481. This is in support of the submission advanced by Mr. Bandyopadhyay that General Causes Act is applicable, section 24.
To 2002 Volume 3
Supreme Court page 481.
481, yes. And another 174 SCC 537.
Page 537.
These both are on section 24 of
Yes,
this?
General Causes Act, right? General Causes Act. Your Lordship, kindly take note of paragraph 17 as has been placed before your Lordship by Mr. Bandyopadhyay at page 490 of the judgment, first judgment.
Yes.
May I read my Lord, paragraph 17? Section 24 of the General Causes Act deals with the effect of repeal and reenactment of an act, and the object of the section is to
2002. 2002 volume.
2002 Volume 3 Supreme Court.
Yes.
Paragraph 17.
Volume 3. 2 Volume 3.
2, 3. Not 3, 2, 2, 3.
State of Punjab.
Kindly read my Lord, paragraph 17.
Yes.
At page 490.
Yes.
Section 24 of the General Causes Act deals with the effect of repeal and reenactment of an act, and the object of the section is to preserve the continuity of the notifications, orders, schemes, rules, or bylaws made or issued under the repealed act, unless they are shown to be inconsistent with the provisions of the reenacted statute. Or specific case, entire thing which has been done in not in consistence with the control order.
Yes.
I have already shown to your Lordship section 24. If it is superseded, there is no question, no consideration.
Next 17.4 SCC.
My Lord, this is also General Causes Act. Kindly come to first paragraph 1. What is the case? And paragraph 26, our case. 537. If you Lordship, kindly allow me to read first, my Lord, paragraph 1. So the dispute between a landlord and tenant.
Yes.
Paragraph, kindly come to paragraph 26, our case.
26.
The 25 and 26. Did not go through the 25 because 24 has been quoted, then 26 at page 543. This is the case between a landlord and a tenant. Eviction suit. That we find none of the conditions which derogate from the continuation of the notification exists in the present case. There is no express provision to the contrary. There is no supersession by any statutory instrument under the reenacted provisions. Kindly take note. This is our case. In our case, it has been superseded. And there is nothing inconsistent in the continuance of the notification with so and so. Our case is, it is entirely inconsistent. Supersession, consistency, inconsistency.
Thank you. Yes.
Now, Mr. Sengupta has argued also before Lordship and relied on two judgments.
2017. 2002 Volume 3 SCC. No, what is 17.4?
He has relied on 2019, volume 19, Supreme Court cases, page 626. 2019.
Just 17-4 was the last judgment. He has not submitted any further document, further judgment. 6 judgments given. And we have in our Sengupta relied upon
2 judgments. Yes,
judgments.
I am on Mr. Sengupta.
No, this 17-4 SCC you relied.
No,
17 II.
17-4.
4 SCC. That is on General Clauses Act.
That is on General Clauses Act. Same.
Yes.
That chapter closed, my lord. So far, Mr. Bandhopadhyay is concerned.
2000 Did anybody rely 2002 volume 2 SCC 318? This is in our. All right, we will check up now. Yes, what do you have to say, Mr. Shahadai?
This is also Mr. Bandhopadhyay. Oh, sorry. Also Mr. Bandhopadhyay, so far as General Clauses Act is concerned.
Now, Sengupta's.
My lord, before that, my lord, kindly give me 5 minutes time. 5 minutes. Because I have understood. Because no.
Let us hear the reply now. We have heard you, sir. Yes.
The first judgment relied on by Mr. Sengupta is 2019, volume 19 Supreme Court cases.
Yes, we have all copies.
2016 and
As relied on paragraph 31.
Yes.
His case is that sought to be argued. I can reply this submission at the time of making my submission so far the private testimony is concerned. That my license is being renewed each and every year. My distributorship or fair paisa dealer's license, so we are the existing dealer and distributor, is being renewed each and every year. For last 30, 40, whatever maybe, and at present for 3 years. There is no dispute. His case is that every time
আমার কাছে আছে এই যে 19 কোনটা চাইছে is so convincing that not a second copy is not required.
judgment is not Mr. Justice Aton's upon each and every year, my license is being renewed. So I have not accrued any right by virtue of 2000 control order, 13 control order.
কি দেয়নি ঠিক আছে আমি শেয়ার করে দিচ্ছি 69 তোমার কাছে এটা রাখো He's, yes, tell us.
Our case is that in National Food Security Act, as also in 2015 control order, it says if anything done, that shall be continued. Our case is that prior to 2013, since we have been granted license, our license, there is no scope to cancel the same. Anything done. This license has been granted to us before coming into force National Food Security Act and 2015 control order. So it shall continue. Mr. Sengupta want to submit before Lordship. No, we have not acquired any right. Because your license is being renewed each and every year.
Yes.
So whenever your license is being renewed,
you come under that fold of rules.
In the meantime, since new control order came into force,
you are coming under.
Coming the same footings. So far this submission is concerned, he has relied upon judgment. But before that, I have to show your Lordship, because this is also the submission of Mr. Senior Bandyopadhyay to some extent. If your Lordship.
Because it is a compassionate appointment.
Yes. So, but first item is, first case is concerned.
That is Sitara. That is
Sitara.
Others are not compassionate appointment.
There are another case also. I shall, out of 50, 60, another case is also compassionate. I shall show to you. So I shall give the details, at least. Another case. But
yes,
if your Lordship allow me to make submission jointly, so far Mr. Sengupta and Bandyopadhyay is concerned, that would be Senior Bandyopadhyay is concerned, Mr. Kolon Bandyopadhyay is concerned. Because almost same line they have argued, but judgment is different.
No, the court single judge held that compassionate appointment issue was decided by the single judge. Single judge that, yes, compassionate appointment.
Discussed but not possibly decided. Right? Discussed but not possibly decided. Yes,
loses relevance. Single judge বলেছে it has lost relevance.
Ultimately, the single judge came to a conclusion, since it is not been implemented fully, these courts lost its relevancy.
Para 50, man. Para 50. Para 50. If you're looking at the impugned judgment, it's para 50.
50.
Honorable single judge held that it has lost relevancy.
Because
this point has lost.
Hey, thank you. Paragraph. Yeah.
It starts from paragraph 48. Yes.
The right to get a renewal of license is not a vested right, but a privilege subject to.
No conclusion.
On such analogy. Yes.
But may I get another day, half an hour, to conclude the entire submission? Any day, half an hour. Just. No. Any day, next to, even tomorrow. Any day.
Argument which was canvassed by my learned senior friend, absolutely, my lord, he has misconstrued the law, knowing fully well. Why? Because section 3.
Hearing Mr. Sengupta.
Let me allow me for 10 minutes.
Reply.
Tell us what.
Yes. But kindly consider one thing.
Never say, my lord, after reply.
Section, you have argued, you are not what new word to you.
New word, yes, that's why.
You let him give the reply. Every new
Then I will get a chance.
if new thing has been submitted, he will get a chance.
My lord, whatever he has.
Don't reapprise your.
No, I am not reapprising. My lord, kindly consider. Kindly just give a half a minute time.
No, this is not the procedure, Mr. Shetty.
Yes, I know. I know that. I am before my lord.
You complete your reply.
Any day, my lord. Half an hour. Not more than half an hour. Any day at 10:30, anytime, even tomorrow. Any day. Anytime. I am not.
No, the thing is, you people have prepared any written notes of argument?
None of it.
Huh?
In fact, my lord, your lordship wanted on the last occasion, your lordship wanted me to find out whether I have a copy of the written notes or not.
Yes.
So I have found out a copy because if your lordship wants to peruse it.
When he finishes, you give us a copy of that.
But I can give, but that is for the lordship record, what I filed.
You give a short note of your argument. Finished. And you also.
My written notes in the single bench will not suffice in the appeal because I have taken an additional point of Order 41, Rule 33.
Very good. No, that we have taken note. We don't want written argument, but for everybody's satisfaction, if it is so, if you want to redraw and reincorporate, you will be.
One I'll give for your lordship's record.
What we are requesting you is that in the meantime, you prepared that so that after finishing again, that give us 2 weeks time to explain. If at all you require, you please explain.
But if Mr. Saharai, my learned senior friend, says something which I have not submitted. Yes.
We are not shutting out everybody. We are hearing a matter for so long.
I have filed an application for intervention, my lord. Only give me 2 minutes time.
Intervention.
Previously, lordship heard it. 1 or 2 days, we have already filed an application for intervention.
We will hear you. The intervention, we will hear you question of further addition of party at this stage.
No, we have filed intervening.
We will hear you and record your appearance so that so far as your contention is concerned. Tell us, Mr. Sarai, when can you come?
Any day.
Any day to hobe na.
Any day.
Well, next week, kindly fix it. Otherwise, my lord, otherwise, my lord, they are showing this order of my lords, and my lord, they are getting that order.
In the
the interim order was up to
31st
January. February.
All the license.
But we are requesting the councils to conclude on.
Yes, 100%, my lord.
And if you want to prepare written notes,
in the minutes, kindly mentions one line in the order so that all the parties are. No one can take time on that day. The one line that written note filed on that day, subject to lordship kind consideration.
6th February.
কাউন্সিলকে নিয়ে এসে মজা করছিস তুই?
এটাতে অন্য ম্যাটার আছে কতগুলি। February at 2 p.m.
Yes. But interim order may be extended. Till না 4th অব্দি করে। 5th এর পর হবে। আমি বলছি। End of January. না না end of January আছে। It can be valid till disposal of the appeal because valid your lordship is
We have extensively heard Mr. Shahada, the if you can prepare that written note of argument by this time, if it is possible, then give us a copy to our court officer so that
Beforehand.
and please exchange also so that there is no. আচ্ছা শোনো এইটার রিট ফাইলটা কি নিয়ে আসবে সিতারা বেগমের রিট it matters. In one matter, it was told you are appearing, which is similar to this matter. So we have kept it that matter. After we finally hear, we can.
No, that's true. But other matters, since
there are no further matters, new applications.
numbers of matters, but it is not being called on. It is not being called on because
it is because fresh matters have been mentioned last Monday only. It was reached, Mr. Saharai. Maybe you were not here. The matters were reached.
In one matter reached. That's the first day.
Not one matter. There were three matters.
The first day, Friday, last Friday. That was a deemed holiday.
We try our level best.
The contention is different.
It is
Content has not appeared in
the contempt application. Contempt application যেটা নাম্বার দিচ্ছ
কন্টেম অ্যাপ্লিকেশন এই কোয়েন শুনতে পারবে না
তো তুমি এই ফাইলটাই আনো
কন্টেম অ্যাসাইন না হলে এখানে শুনবে
এটা তো কার কাছে
কন্টেম তো অ্যাসাইন না
রেগুলার বেঞ্চের কাছে
একজন বেঞ্চ তো একজন জাজ তো রয়ে গেছে
আসলে
কন্টেম্প ফাইলটার সাথে রিট ফাইলটা আছে না কন্টেম্প তাহলে রিট ফাইলটা কোথায়
but possibly your lordship may not hear out the contempt application because
no we are wanting the রিট ফাইল
yes
সেটা কোনো জজের ঘরে যদি থাকে টেনে এনো না আর কি
রিট ফাইল লিস্ট
জিজ্ঞেস করি রিকুইজিশন দেখে নি